This was challenged in the appellate court. Appeal also confirmed that. In spite of that, they are publishing a fresh advertisement, not calling for the old new committee. I filed that, and the date has been fixed for tomorrow. I have got a diary number. I'll give the memo that can that
diary number will not be listed unless you remove the defects. Why don't you remove the defects?
Office, our difficulty is 3 days back we file it, so they are not making that waiting. That you have got a time to make the and that is why you are making a mention. Otherwise, I would not have made a mention.
So, what order can be passed by the bench?
My lord,
what order can I pass?
My lords, I will give if the to be listed for tomorrow, then automatically they'll go for a. We'll see that.
Right, listed.
I'll give that memo.
Give a memo.
Just now I'll ask my associate.
Memo so
that we can remove the defect if
yes.
But another matter, my lord.
Yes.
2017 admission matter, after notice matter, the relative selection of Shiksha Sahayaka. 2017. See now 2024. Tomorrow they are.
अच्छा मो फेब्रुआरी में मत दिल्ली नहीं होगी
तो अब अपन तो मो फर्स्ट टाइम देखुजी अपन फेब्रुआरी में केतो देले
ना मो सेट दो चार्टर दिशा में 5th दो
चल अपन अपन नथि हम जानि पन
2 मीटर सर्वे
2 मीटर कोन
सर्वे किछि ना मो दरकार पले उड्रो भी कर देबे काने साउ अन्य देई पर
आज उड्रो कर दो ना
काली के
साइड डिस्पोज होई जो
काली एटा पर 50/24 My lord, last date order that it should be listed on week commencing 1st July for consideration limitation, but it's not come.
Your second appeal for admission a week before I had met Mediation.
Offer matter associated. You see, Mr. Pradhan, because of the miscellaneous matters. नहीं कौन करा जो कोनो सबुत किछि किछि आना गोटे डिफिकल्टी होचे
Final decree proceeding is called.
नहीं we will state किछि असुविधा
One modification.
My lord, modification, this order was passed on 11. Upload ହେଇକି full ଟିକେ ହେଇଯାଇଛି तो certified copy ପାଇ ନାହିଁ
देन कर दो
एई पार्टटा अंडरलाइन कर देई सेटा अनगुल होबा कथा फैमिली जज अनगुल होबा तालचे रे सिविल जज
कर दो जदी अपलोड होइन कर दो दे दे have you corrected it?
Yes underline कर दे जो पर्सन ता करेक्शन होबा
mention will not be the second of the limitation hearing by recovery.
One file one memo.
Your Lordship, one was your Lordship directed to.
Sir, please file one memo.
Okay.
You decide which one to file. Tomorrow you may file another memo, but today, yes.
One tired of bail matters. Custody since more than 8 years.
नहीं लाइन होते नहीं
डेट ये लड़ से इश्यू का नेक्स्ट वीक एनी डेट
इसी चलसी ना नहीं थे बुझलो देखो ये पूरा झाड़ी जी इसी जगह देखो
Quickly tell you item number 1.
In the result, the writ application is partly allowed. The opposite party authorities are directed to compute the minimum pension payable to the petitioner for the period of service rendered under the government establishments and to disburse the same in his favor as early as possible, preferably within 2 months from today. The other part are not allowed because he had 10 years. So,
Item number 2.
in the result, the writ application succeeds and is therefore allowed. The opposite party authorities are directed to pass necessary orders to regularize the services of the petitioner in the post of artist with effect from with effect from the date he completed 6 years of contractual service along with all consequential service and financial benefits within 2 months from today.
Item number 3.
For the foregoing reasons, therefore, the writ application is allowed. The impugned order dated 19/10/2013 of the Collector of Kalahandi and the consequential orders of disengagement dated 5/11/2013 and 8/11/2013 are hereby quashed. Further, the notice dated 8/11/2013 inviting applications for fresh selection of ASHA workers is also consequentially quashed. Necessary orders be passed to allow the petitioner to continue as ASHA worker of Undelivered sub-center under CHC Junagadh within 2 months from today by reinstating her if the impugned order of disengagement has actually been acted upon in the meantime.
Item number 4.
In the result, the writ application is allowed. The impugned order under Annexure 7 is hereby set aside.
Number 5.
एसी चालू नहीं कौन सा
So may I please your lordship? Your lordship, I filed this application for transfer of civil proceedings 802 of 2023 from the Court of Family Judge Cuttack to the Court of Family Judge Puri. Your lordship.
Why?
Your
You're the wife.
Yes, your lordship, on the behalf of the wife. Your lordship, I basically filed this application based on two grounds, your lordship. First one, she's a 37-year-old woman living with her two minor children and old and ailing parents, your lordship. She has no financial support neither from her husband nor physical
All
support.
issue
from any-
notice to the opposite party by speed post, fixing a short returnable date, requisites be filed by tomorrow peremptorily, list this matter.
July 29.
29. Date ওরা দেখছে তো? Seven side have huh? All right. Yes.
Obliged, your lordship.
Item number 6.
You have an IA?
Yes, your lordship, IA is pending, your lordship. My apologies.
You are not interested in pursuing that IA?
Your lordship, my apologies.
You have to apologize. You apologize to your client, not to the court.
Your lordship, IA is
When the client has entrusted the brief to you, he has reposed his trust on you and confidence on you. You have to do justice to your client.
Yes,
Adjournment, huh? Adjournment. Adjournment means if you make an application for adjournment in the court below, it will be considered.
I'm sorry, your lordship, IA is filed. Kindly, your lordship, may kindly.
That is the order I'm passing in the IA. This is the order. That is the order passed in everybody's case.
Obliged, your
Item number 6.
Next time onwards, pay attention. Yes, Mr. Mathi, what is this?
Lord, is that extension of each, my lord senior has to bring an instruction on the decision.
There was
of
a
the-
meeting, my lord, which was scheduled.
This is assigned to court number 10. Why has it come to me? Court number 10 is functioning today, I believe.
Yes, ma'am.
So it has to go back. I cannot take it up. Oh, see, you 26 कौन हैला सेटा?
30 জন, yes,
ମାଗିଛି sir instruction ଟାକୁ ସେମାନେ ମାନେ
30 জন already relieved. So, but
He must have already been relieved. अब कौन
yeah,
कर जाए?
36. How it,
Is this matter before the assigned bench?
lordship,
Item number
it has to go to assignment, but date, my lords, I'm
Yeah.
concerned, a date also, or it has to be mentioned, it has to be listed.
No, I'm making a mention here. This is a judicial order I'm passing.
Yes,
List this matter before the assigned bench. Let us say tomorrow.
grateful. lords.
Item number 7.
May I please, ma'am?
Yes.
My lord, the petitioner is working as a Gram Rojagar Sevak and regularized as data entry operator, my lord. My lord, in the case, my lord, of the one order has been passed by the Honorable Lokayak, my lord, that some allegation was there like regarding Pradhan Mantri Awas Yojana. And out of 20 houses allotted, 4 has been allotted to ineligible candidate. And that was the allegation before the Lokayak, my lord. And Lokayak passed an order that initiate departmental proceeding and recover the money given to the ineligible candidate, my lord. My lord, in respect of other employees, my lord, the departmental proceeding has been initiated. But as this petitioner was Gram Rojagar Sevak and at that time, and now he has been regularized. They have not issued so cause notice to him, my lord. And so without giving him, and they are saying that he will be disengaged directly without,
Where is that order?
no, that order is not there, my lord.
So
My lord, but the so notice memorandum and article of charges has not been issued to him.
what is your cause of action?
My lord, he is apprehending that they will directly disengage, my lord. Well, only my lord can say that without giving him opportunity of hearing, they will not take any question.
No, why will you apprehend that they will not follow the procedure? They have done nothing. They have done nothing. So,
They have issued, my lord.
What about
Other
that?
employee. And
No, other employees they may have issued. We are not concerned with it.
in respect of 3 employees, the Lokayak has directed to.
No, I will grant you liberty to move the court whenever any cause of action arises. Now it is on an apprehended, Mrs. Mahanti, on an apprehended cause of action, the Red Court will not interfere.
And I understand that, my lord, but if they directly disengage him, my lord, after serving for 14 years, he have been regularized only in 2024, my lord. And only in.
There is no cause of action.
Yes, I
Unless there is a cause of action, how can I pass any order on it?
Only opportunity of hearing should be given before taking any coercive action. This much observation may be kindly pardoned.
That is the order of the honorable local.
Order is to
That is the order of honorable.
କାଇଁ ସେଟା କାଇଁ order of
order it is here. Order
କେତେ annexure କେତେ?
annexure 8.
It is a 10 or 54.
Annexure 8, my lord. The circumstance we recommend that departmental proceeding be initiated against the aforesaid 3 public servant and the amount already paid to the beneficiary let so and so be
All right.
recovered.
The petitioner is initially joined as Gram Rozgar Sevak and was subsequently absorbed in the regular cadre of accountant cum data entry operator.
Yes.
On the basis of a complaint, an inquiry was conducted by the learned Lokayukta in case number LY-1117 of 2019.
Yes.
Stop. By order dated 15/9/2022. The said case related to allegations of misappropriation of government funds in कौन सा की scheme
Pradhan Mantri Awas Yojana.
in relating to Pradhan Mantri Awas Yojana. The petitioner is said to be one of the delinquents, one of the persons involved in the misconduct. The learned Lokayukta, while order dated 15/9/2022, disposed of the case inter alia with the following direction. Para 9 quote कर दो from page 54. गौरव मुझे इसी चल रहे है ना page 54. The petitioner apprehends that though no action has yet been taken against the petitioner, yet he apprehends that he may be disengaged by the authorities without following the due procedure of law. Stop. This court does not, this court fails to understand as to why the petitioner should have such apprehension, as the opposite party authorities, being government functionaries, are expected to act strictly within the parameters of law, and particularly in matters relating to disciplinary action, the provisions of the OCS bracketry CCA rules are to be followed. Stop. This court finds no reason as to why such procedure shall not be adopted in case of the petitioner before taking any drastic step. Stop. The writ application is therefore disposed of with the above observations.
Number 8.
And it is Sunyaru.
କହିଲେ ସେ 14 ବର୍ଷ ତାକୁ ତ ଧମକେଇଲା ବେଳକୁ ତାର 14 ବର୍ଷ ପରେ ରେଗୁଲାର ହେଇଛି ଏଇ ବର୍ଷ ଆଜ୍ଞା
14 ବର୍ଷ ପରେ ରେଗୁଲାର ହେଇକି କିଛି ପଇସା ଖାଇ ଦେଇଛି ତ
ନାଇଁ ପଇସା ସେମାନେ ଖାଇଛନ୍ତି ବୋଲି ଆଲିଗେସନ ନୁହେଁ ପଇସା ସେମାନଙ୍କ ଆକାଉଣ୍ଟ କୁ ଯାଇଛି ବଟ୍ ଇନଏଲିଜିବଲ କ୍ୟାଣ୍ଡିଡେଟ କୁ
ସେଇ ବାଟରେ ତ
ଦ୍ୟାଟ ହାଜ ଟୁ ବି
କଣ ପ୍ରମାଣ ହବ ନ ହବ କିନ୍ତୁ କଣ ଗୋଟେ ହଉଛି ଘଟଣାଟା କଣ ଆମେ ଜାଣିପାରୁନୁ ନା ଆପଣ ଜାଣିପାରୁନୁ Yes.
Covered by Dhananjay Chan there.
Yes.
Covered by Dhananjay Chan there.
Order कर
Individual defendation से कॉपी भी देचा.
देखिए कर दो
All connected matters.
item number 9. I am from the opposite party. Can be counter. Having counter.
Either is appearing for OP number 5. Just now he served a copy of the counter.
We will take it up next week.
And your lordship may kindly see the notice on OP number 6 is sufficient, but nobody appears, my lord. So that will be listed for hearing next week.
Yes, yes. देखिए notice is sufficient.
Yes, my lord.
Last occasion order has been passed.
Okay.
In respect to opposite panel 6.
अच्छा already been delivered by लिखा है postal tracking report on sir
Yes.
Sri Sharma, learned counsel appearing for the opposite party number 5, files counter affidavit in the court after serving copy on the counsel for the petitioner. List this matter what a week for a karo.
29 July.
29 July
Fine.
for final disposal. Yes. The affidavit be kept on records.
Item number 10.
Yes, item 10, pass over.
Item number 11. Item 11, your lordship has had it with us, appointment of ASA relating to a village. The lordship had told that only.
हाँ मुझे कहते लीजिए हाँ कौन खाली just briefly मन पकड़ दूँ keep it.
It said that selection has been made in respect of Jingpada village, and thereafter they have again published an advertisement stating for the Jingpada village. In that also the petitioner is selected. Thereafter they have in the year 2017 they have again published an advertisement which has been challenged by the petitioner stating that ward number 1. But the guideline doesn't say about any ward number 1 for the village. For every 1,000 people there will be one ASA. And last occasion
it has been made ward wise.
Ward wise they have now done, and in the counter affidavit they have admitted they have cancelled it in the year 2017, though she has selected in the year 2015.
Yes, anything else, Mr. Sethi, you would like to add?
My lord, I am the intervener. By virtue of the intervention petition, I am allowed.
Was your intervention allowed?
Already allowed.
You are already, so that means you are the private opposite party now.
Yes, my lord. Yes.
Yeah, I think on the last occasion you had made your submissions, isn't
Yes,
it?
my lord.
Anything else you would
I
like to
kind
add?
of glance the advertisement. It clearly mentioned that one or one by
Sir, देखिए I said that argument.
2017 advertisement selection.
And anything else?
I have already provisionally
I'm
selected.
closing it. I'm closing it.
My lord, I have already provisionally
Your
selected.
lordship wanted to know that in absence of any provision in the guideline, whether there is any possibility of making it selection ward wise. So, though my lord, I have not received anything in writing, my lord, but I just wanted to get information from the authorities, and what they shared me that they are actually associated with the Anganwadi workers. So since Anganwadi workers are usually, they have the defined service areas. So accordingly, these persons, my lord, they have also decided to go for ward wise. But there is no such guideline to that.
Well, we'll see. Hearing concluded, judgment reserved.
My lord, I have already provisionally selected due to stay out. I could not.
Parties may file their note of submissions and memo of citations, if any, within a week. Yes.
Item number 12.
May I please, your lordship, matter, my lord, regarding disengagement of the GRS. My lord, the petitioner was appointed a GRS in the year 2006. In the year 2017, my lord,
So the state is opposing you.
my lord, a paper clipping came out, my lord, in the Odia Delhi Deep Pramaya that the GRS, the present petitioner, has held the ATM cards of some of the beneficiaries in order to misappropriate government money.
Yes.
Accordingly, my lord, a so cause was issued. I filed my reply. Thereafter, I was disengaged by the collector Balangi. I challenged this order before this honorable court. This honorable court was pleased to set aside the order of disengagement by the order dated 21/2/2022 under Annexure 5 and directed the collector Balangi to hold fresh inquiry by giving opportunity of hearing to the petitioner, my lord. Thereafter, your lordship may kindly see under Annexure 6, my lord, a miscase was registered, miscase number 11 of 2022, and the collector Balangi again upheld the disengagement order, stating that there were ATM withdrawals from the beneficiaries. But with great respect, my lord, there is no criminal case instituted either by the state or by any of the beneficiaries that the ATM withdrawals money have been taken by the petitioner and their houses have not been completed. I have given the information sheet given by the government, my lord, that the houses of all the three of the beneficiaries have been completed and not a single pie has been misappropriated. And your lordship also went through the perused the Annexure 6 on the last occasion also and made a query to the Learned State Council that only by ATM withdrawals, how it is related that there was not completion of the work or the petitioner has misappropriated when there is no criminal case or no allegation either by the beneficiaries or by the state.
Yes.
In this case, my lord, there is two things. There are two things. One is, my lord, relating to decision taking process, and another is, my lord, the decision itself. The petitioner has challenged the decision.
Both. He says the appellate authority in the impugned order has held that at the time of hearing, the appellant admitted that he was in possession of the ATM cards and bank passbooks and made transactions from those accounts to his own account using ATM card. Really, Mr. Nandan instruction submits that this is a wrong statement as the petitioner had never made any such admission. Actually, what is the law? I think it is Air Anthule or something, I'm forgetting. If there is mention of a statement made by a party before a court, which he says that he has not made such a statement, then you have to, the law is that you have to submit an affidavit before the same court saying that your order should be modified because I have never made any such admission. Coming to the higher court, how will the higher court now decide? He is the best authority, best person to decide is the appellate authority itself. So you should have made that application that your order needs to be modified, or this particular statement or this particular portion of the order has to be expunged. That I have not made such an admission, but you have held that I have made an admission. Such a thing has not happened.
There was COVID period, my lord. By video conferencing only he was present.
So that is what.
He also asked me, lord, on the EPL lordship will kindly say it is just only the replica of the collector's order.
Maybe, but how can this court make a factual inquiry and decide whether we have actually made an admission or not?
And your lordship may kindly say, if it is true, my lord, how can the houses be completed?
No, that is a different matter. We will go to that.
Your lordship may kindly say their own admission by the information.
Mr. Nanda, there are two things as the State Council has pointed out. First is the decision-making process, and second is the decision. We'll go to that decision. We'll go to that, irrespective of whether you are admitted or not. We'll have to find out whether that allegation is made or not. That is the second thing. So, but the first part, anyway. Yes, what is your instruction?
There is no subsequent instruction in this case, my lord. With respect to the information, what it is available in the record, my lord.
So what he says
Yes.
is that he was in possession of the ATM cards of the beneficiaries.
Yes.
And some amount appears to have been transmitted from, according to the allegations, from the beneficiary's account to his account. So this can be verified.
It has been there.
Where is that proof?
Well, initially,
Apart from the so-called admission, where is
there was
the
an inquiry.
where is that proof?
Well,
Let us see.
inquiry.
Let us
Well,
see.
initially, my lord, one inquiry was conducted. This petitioner was not satisfied. Then he approached before this honorable court. Then thereafter, my lord, the matter was remitted to the authorities to consider. Then a fresh inquiry was conducted, where the petitioner had participated. After that, my lord, that inquiry, basing upon that inquiry report, a decision was taken. And then once again, my lord, he approached before this honorable court. Thereafter, an opportunity was given to him.
इसीलिए चालू नहीं फैन रेडी दे नहीं इसलिए चालू नहीं तो कौन कहीं तो प्रॉब्लम नहीं है इसीलिए इफेक्टिव ये तो yes.
Thereafter, my lord, he approached before this honorable court. Then the petitioner was granted with the liberty to file an appeal. Then he preferred an appeal, and the appellate authority also conducted they completed that appeal hearing, my lord, after giving due opportunity to the petitioner. So in this process, my submission, my lord, the inquiry proceeding was there, and that report was utilized, and sufficient opportunity was given to the petitioner in order to reach to such a conclusion. So, my lord,
no, before accepting your contention in full, this being a statutory proceeding, this court would like to know whether whatever was alleged against him, was it proved?
Yes, that is in the joint inquiry report, my lord, if your lordship will come. That has been enclosed, my lord, in our counter. My lord, it is 15, page number 15 to 50, my lord.
Yes.
unnecessary by 3, my lord. And thereafter, my lord, in conducting this inquiry, they discussed in detail, my lord. And the contents of this inquiry report is not in dispute, my lord. So, with respect to the
No,
allegations raised against him, my
no,
lord.
it can be treated as in dispute because he has filed an appeal.
My lord, so, but initially, my lord, directly he challenged. Thereafter, my lord, this is the second inquiry, fresh inquiry report, after giving opportunity. Then he submitted an appeal. And in that appeal, my lord, the appellate authority passed that order, the impeachment order, my lord. So, my lord, with respect to the inquiry, what is the irregularity, my lord? What he is making a submission? With respect to the charges, allegations, and the conclusion derived, my lord, he is making the allegations, my lord. But with respect to the inquiry and other things, my lord, in order to reach to such a conclusion, my lord, there is no serious, there is no allegation with respect to irregularities. So there are allegations, my lord, and those are inquired upon. And after conducting the inquiry, my lord, they reach to such a conclusion. Now, with respect to the additional points, what is raising, my lord, during the process of hearing the appeal before the appellate authority, thereafter no additional information which is
All right,
available.
I'll close it.
Yes, ma'am.
I'll close it. Hearing concluded, judgment is out.
Grateful, madam.
Item number 30. It may be permitted to argue on behalf of Mr. S. Mahapatra, your lordship. The original lead petitioner has been died, and on the substitution of her husband, your lordship, the original petitioner challenged the.
She has been substituted.
My lord,
His legal heir has been substituted.
only his her husband has been substituted. Because it's a matter of family pension and the retirement superannuation. Your lordship, he has been challenged before your lordship. The order dated 8/11 of 2012 of her retirement and superannuation at attaining the age of 60, your lordship, who has been served as a junior lecturer and who had been selected for promotion of assistant professor in the same college, your lordship, under Annex 2 as per the UGC guidelines, but her selection has been cancelled under Annex 3, your lordship, that is running page 11, and others have been 28 posts have been, though 31 posts approved, and this petitioner was there in the under Annex 2, but in under Annex 3, her selection has been cancelled and others have been appointed as assistant professor as per the UGC rules, your lordship. Thereafter, under Annex 5, your lordship, she had been represented, and then Annex 1 for appointment at attaining the age of 60, your lordship, when the UGC guideline, as per the UGC guideline 2008, the superannuation age is at the attaining of age 65, your lordship. It is the admitting fact that the selection of this petitioner in the counter, their counter, your lordship, para 7, your lordship, going through their counter, your lordship. Why I am showing to that? Para 7 of their counter, I am going to that. That in reply to the affirmance made in para 4 of the writ application, it is humbly submitted that 31 post of assistant professor to replace the existing TGT and PGT research assistant junior lecturers were created as per the decisions taken by the Ministry of HRD, Government of India. The petitioner was also considered, but was not found eligible, considered at the Annex 2, my lord, but not found eligible for the promotion to the post of lecturer or assistant professor because she does not possess the 55% of marks or above in her post-graduation 28 graduation. 28 candidates out of 31 newly created posts were found eligible for promotion to the post of lecturer.
So what is your reply to this?
My submission, I have replied, your lordship. I have filed my rejoinder, your lordship, my rejoinder annexure R by 1, your lordship go through that.
Yes.
One page I have given, that is more than 25 pages. I have given 24 pages. In this, your lordship, main criteria of the UGC, in view of the above, only 8 posts that selection of prior selection, what they have taken, subsection 3, your lordship. Junior lecturers or RS possessing above 50% in marks in their respective postgraduate degree without possessing PhD degree, and those who have less than 50% of marks in their respective postgraduate degrees but have the PhD degree, to their credit, may be considered for promotion provided they have put in a minimum of 16 years of service.
12 years, 12 years,
My lord,
12 years.
that is, my service is more than that 30 years.
But you do not have 55%. Do you have PhD?
No, I have not.
So
my PhD.
55% requirement is there. Mamata Mati versus State of Odisha.
I have secured only 54.28%. That is admitted fact. That is not. But my service for more than 30 years has not been considered.
The basic GST sheet calling.
That is the basic fair count.
The junior lecturers, RAs, possessing.
My posts have been approved, but they have stated that
No, for being granted UGC scale, 58% is necessary.
yes,
For being appointed as such, without UGC scale, 55% is not required. So your post has been approved. But
during that they annexed 2, they have stated my post have been approved.
yes, what do you say, Mr.
Under annexed 2, your lordship, they have
Union
I think Union of India.
Union of
Union
India.
of India.
Yes,
UGC is there, so you
Mr. Mahanti was there, I thought.
No record has been provided to us.
You have nothing to say in this matter.
they have admitted that my post have been approved, but I am not eligible.
Even if you have been approved, I don't think this requirement of 55% is mandatory. That has been decided in Mamata Mahanti.
I'll go through that.
And they say, in Mamata Mahanti also said, she will be eligible from the date she secures or that acquires that qualification of 55%. You can improve upon your MA course, can you not? Upon say, एक case नहीं, but one can improve. सारे परीक्षा दला तार 40% ले से आउटर परीक्षा देखी तो 55% आने दला. So that can be also a factor. But anyway,
The only thing in this case, why I am drawing your attention, your lordship, only thing is that when I have solved and that my post have been approved,
we'll see.
thereafter my ineligibility is seen.
All right, we'll see that.
That is to be considered.
All right. Learned counsel for the petitioner is present. None appears for the opposite parties on repeated calls. List this matter next week. In order to grant, in order to grant an opportunity to the opposite parties to have their say in the matter. Next week, got an opportunity. The
Petitioner had been died originally writ petitioner and her husband it there, your lordship.
Yes.
Oh, right.
Item 14. All right, pass over.
Item number 15.
ଆମର ଏପଟେ ଗୋଟେ ଇଏ ଦରକାର ଫ୍ୟାନ
हम तो पैसे पे फैन टाणी लगा नर बसे हो हां तुमको फैन टाणी गोटे की दीटा फैन आनी लगे यस
My lord, here, your lordship, I am requesting your lordship's memory that Anganwadi worker case where in 2009 selection was made. I am the highest, I have secured the highest mark, but they didn't take any step for my appointment. So I came before your lordship. The lordship directed to do it within 4 months. They didn't do that. And thereafter, I have filed this writ petition. My lord, they have come up with the case that there is a resurvey in the area for which it could not be done. Your lordship, and the collector has passed the order. I am challenging the order of the collector, that is page 23. relevant portion. Class 3 para, my lord, that will may I read.
Yes.
The contention of the petitioner said that they were the applicants for the post of Anganwadi worker for Hon'Ble B, AWC, as per the advertisement issued by so and so by the CDPO Jagannath Prasad, indicating the area of the said AWC. As per the advertisement, 8 candidates, including the present petitioners, had applied for the post. But as objections were received with regard to the area of operation, the process of selection was held up. In order to solve the area dispute, selection committee meeting held on 31/10/12 decided to divide the area of Bhusandapala A and B properly and proportionately and to place the matter before the BLCC for approval. But till date, this has not yet been done. Since the matter has been badly delayed and the area of jurisdiction was not properly surveyed, the application received during so and so as hereby. My lord, I am aggrieved by this. They have filed the counter affidavit. My lord, your lordship, I have gone to the counter page 7. After, my lord, survey, this advertisement has been issued. Then your lordship may kindly turn to the, when they have decided in 2015, the next annexure. Then your lordship may kindly turn to page 2 of their counter affidavit. Subpara, it is submitted. The arguments that the petitioner was selected is incorrect, as no one has been selected on the basis of the notification advertisement so and so. In total, 8 candidates had applied for being considered for the engagement at Anganwadi Center. For the said center, objections were invited. During this period, your lords, I am emphasizing this. During this period, 5 objections were received, wherein objection was raised with regard to the validity of the service area on the ground that the same was defective, as it didn't conform to the requirement of the guideline and circular. My lord, they have not filed any objection here. In order to cover up their own fault, they have stated so. And in the process, I am the victim.
No, but they say that nobody was selected.
No, nobody were, my lord, I have secured Hasmar. So before they didn't issue any appointment order, for which I came to this honorable court.
What has happened in the meantime?
Nothing has happened.
Yes?
Nothing has happened. And my submission before your lordship is that why I will suffer for their laches. Right now, I am overage. Right now also, my
have you examined the law in this regard?
My lord, law, your lordship wanted to indicate what?
No, law in the sense, there are 2 things. First of all, you have not been selected as such. You secured highest marks, so you had a legitimate expectation of being selected.
Yes.
So as such, you don't have any vested right.
No.
That is one part.
Yes.
Second part is, it is always open to the employer to not to fill up the posts, to withdraw the advertisement, but the action cannot be arbitrary. So you have to
within this parameter, I have to.
You have to convince the court that the action taken by them is arbitrary, because you don't have a vested right.
No, I don't.
Only by being included, even if, and here, as you yourself said, no select list was,
No.
prepared. You being you having secured the highest mark, you have a legitimate expectation. That's all.
Yes. The lordship may keep it to next week.
Yes.
Let me
Yes.
address your lordship on this.
Yes.
Score.
Specifically, and I am giving you the law.
Yes.
Even in Shankar Sanadas versus Union of India, that Constitution bench decision. So mere inclusion in the select list does not grant you.
No.
But when the authorities act arbitrarily, then you have a
Right.
right to say. And even then, no mandamus can be issued to the authorities directing them to straight away appoint you. They can only continue with the selection process which they had undertaken. That's all.
Only that much. Yes.
Yes. Heard in part. Let's this matter in the heard in part. The learned counsels of the parties are requested to address the court as regards the right of the petitioner to challenge the impugned action of the collector, of the authorities. Stop. You can understand what, yes, place this matter next week or day.
22nd.
Eh?
22nd.
22nd. It's purely on a question of law.
Yes, yes, question of law. Oblige.
Number 16.
Pass.
All right. Pass over.
Item number 17.
Pass over.
Item number 18.
May I please address? Here, my lord, I am challenging the order passed by the ADM in Anganwadi Appeal number 2/2020, setting aside the appointment of the petitioner as Anganwadi worker. The fact of case is that petitioner was appointed as a Anganwadi helper in the year 2001 in Danpur Anganwadi Center. In the year 2017, one Anganwadi worker died. Thereafter, the CDPO appointed as a Anganwadi worker to me on the ground that I have required qualification, and I have also initially appointed as a Anganwadi helper and completed my 5 year services. So accordingly, I appointed as a Anganwadi worker in the year 2018. After 2 years of appointment, in the year 2020, the private opposite party number 4 and 5 filed an appeal before the ADM for setting aside the appointment of the petitioner on the ground that no notification was issued by the CDPO, and the present petitioner belonged to the ward number 8. So she is not entitled to holding that post matter. And the ADM also on that ground reject to set aside my appointment order passed by the CDPO. My humble submission before your lordships kindly see the appointment order, that is Annexure 3, page 11.
Yes.
My lord, as per the revised guideline, dated 2/5/2007, there is a criteria under which basis the Anganwadi worker will be appointed. As per that guideline, in paragraph 4, my lord, if you lordships kindly, paragraph 4, I am placing that right. Anganwadi helper and organizer, if having the requisite qualification and are found to be suitable, shall be selected as Anganwadi worker, provided they have worked for more than 5 years. So when I have completed my work for 5 years, so the CDPO has rightly appointed me as a Anganwadi worker.
The interpretation is different. Otherwise, they would not have used the word suitable and selected. There are two words. Suitability, which can be determined only in a selection process.
Yes.
What it aims is that you will get preference. It means that. Yes, Mr. Patnaik?
Yes.
What would be the interpretation?
My lord, that is the law, my lord.
Plain interpretation is that there cannot be straight away selection. There's a straight away appointment of somebody, Anganwadi worker, even if she, Anganwadi helper, even if she possesses the required experience. That is one aspect. But second aspect is that, rightly or wrongly, that appointment was made. It has been challenged at the instance of rank outsiders.
Promotion.
Hmm?
By way of promotion, which is not permissible.
No.
What is it? What is that, my lord? It is reflected in the appeal order. By way of promotion, by way of promotion, the Anganwadi helper, my lord, she has been promoted to the post of the Anganwadi worker. And that is why the appellate authority decided that it is not in conformity with the revised guideline of.
You satisfy the court?
My lord, here my lord, the opposite party number 3 and 4, who is the private opposite party, they have no locus standi. My appointed was
Even if you ignore their,
my
it has somehow brought to the notice of the authority that the appointment is dehorse the rules.
here, my lord, and as per the separate ground, my lord, in the counter filed by the private opposite party, they have annexed a document. If your lordships kindly see the annexure D, my lord.
Annexure D. Counter, अरे counter था कौन कोर्ट है नहीं? निकली? Have you not filed your counter? मैंने court file करना e-filing कर सकती?
Then counter filed by the.
No, that is also not there.
I filed that counter before this. Honorable.
No, are you a party in this case?
My lord.
Yes.
How?
The private opposite party.
I am private
the
opposite party on whose instance appeal has been filed pursuant to the direction of this honorable court in WPC.
देखिए चले. Counter थी.
4 and 5.
हाँ. 4 and 5.
4 and 5.
Yes. What document were you referring to?
My lord, they have annexed a document notification, my lord, meeting, my lord, annexure T, page 17, 17.
On 7.
My lord, the meeting was held by the selection committee.
Yes.
My
Yes.
lord, second paragraph, my lord. All the sorry, my lord. First, at the outset, a general discussion on implementation of various programs pertaining to ICDS project in respect of district was made. Afterwards, the chairman outlined the purpose of holding today's meeting, that is selection of Anganwadi worker for 3 Anganwadi center of ICDS project database. All the relevant records maintained by CDPO in connection with the selection of Anganwadi workers were placed before the committee for necessary perusal and verification. The committee verified the details of the application so far received from the candidate in response to notification number 697 dated 13/11/2017. It is observed that all the applications received from the candidates have duly been scrutinized as per schedule given by the CDPO. So also taking the result of scrutiny into consideration, due notice inviting objection, if any, against the valid candidature of the candidate have duly been published center-wise mail. So thereafter, the Anganwadi center, the name of the Anganwadi.
What is the Anganwadi center name?
Danpur.
Kanpur.
Mail. And the Anganwadi center.
Last.
Page 19, 19.
Danapur, yes.
Mail. As against the existing vacancy, we have received an application from Saraswati Sarangi, Anganwadi helper of this center. As per government guidelines, she is eligible to get observed her as Anganwadi worker. Hence,
Is there was there any advertisement?
my lord, as per the my lord, as per the meeting, my lord, they have
If there is
stated.
no advertisement, then that becomes difficult.
My lord,
It becomes difficult.
my lord, as per that committee, my lord, as per the committee, the notification was held in the year 2017, my lord.
Which notification?
For appointment of Anganwadi worker.
That is the original notification, as for which somebody was appointed and she died.
No. My lord,
So this is against a casual vacancy.
casual.
vacancy. So it has to be advertised. It has to be notified again. That has not been done.
So the lordship will come to page number 13 of the interim order. There the parawise comment of the CDPO has been taken into consideration.
Now, page number 13 होगा
Sir,
ये 15 और 16 देखिए जिन पेज का appellate court order का
more page more page करती से.
15, 16.
ये आंगनवाड़ी appeal number 2/20 लिखा है इसका
Yes,
हाँ.
yes.
वो अपना paragraph कौन
Well, in the second page, top para. Yeah, second para. In this regard,
in this regard
a factual report was called from the CDPO database, and the same is received and attached by this office, which forms a part of this case record. The CDPO concern has stated that in these type of cases, there is no need of fresh notification as required except the willingness of the Anganwadi helper of concerned Anganwadi center. If the Anganwadi helper having the HSC certificate passed in her favor and have worked for more than 5 years in the same AWCs, she shall be selected as a AWW in the concerned AWCs. As per the government guideline, the respondent number 2 appointed respondent number 1 as AWW. In Danpur AWC, according to government guideline, there is no irregularity has been made. The proceeding of the selection committee annexed with the report reveals that against the existing vacancy, an application was received from Sonolita Sorangi, AWS, from the Danpur AWC. As per the government line, she is eligible to be observed as AWW. After proper verification of documents in her favor by the committee, she is selected. Only this much. So there was no notification, there is no advertisement for inviting the applications, madam.
That is the
In terms of the 25/2007. So that is the documents which are taken into consideration by the collector. And
See, it boils down to interpretation of that clause 4 or
Yes.
paragraph 4, whatever you call it.
But my lord, I think my lord, just now, my lord, I am not getting that. There is a guideline clarification after 25/2007
Please
that
let
in case of death, a fresh notification is to be issued.
So it forms a casual vacancy.
Yes. There is a specific notification.
That is notification number 110/2010.
Yes.
How do you bully दियो? How do you bully दियो? How do you bully दियो? ना सपोर्ट कुनो जिन लॉयर मान को पूरा हबो सेंटी कर दियो एपटा भी सेंटी कर दियो तो बुले दिए चारिटा जिन तो हबो ना ये अजथारे से पहुंची यार अच्छा हो ठीक है सपोर्ट भी देखो दीदी सपोर्ट भी कर दो all right so this is all interpretation you find out
On that point, I'll say
yes you find out decisions make some further research
It is in page number 85 of that book. My lord.
85.
there is no concept of re-engagement or engagement without selection देख ले if any vacancy arises out of death non-joining disengagement resignation fresh selection will be made for the concerned AW.
Yes.
What will happen is you being an Anganwadi worker in the selection you will get precedence
She will get the preference. My lord.
you will get the preference. So even if we ignore the objection raised by the locus standi of the people, even if we ignore it has been brought to the notice of the appellate authority
Yes, ma'am.
that the selection was not in consonance with the rules.
And the CDP also admits that, my lord, they have not conducted any selection.
Yes.
I will, if your lordship's permit,
Navrampur to family court, Bhubaneswar, my lord. But from the side of opposite party, nobody is there.
Anybody appearing for the opposite party?
I'm for petitioner. Notice was sent on dated 16/11/2018. Again, fresh notice was sent on 19/11/2018.
Somebody's name is appearing?
Yes, my lord.
Kick it out.
But
All right. We'll grant one more opportunity. If it doesn't appear, we'll dispose of. Sri Sahul,
Next
as
week.
counsel for the petitioner, is present. None appears for the opposite party on repeated calls. In order to grant another opportunity place this matter tomorrow.
item number 20.
Item 20. All right, pass over.
21, item 21.
Pass over.
Item number 22.
Pass over.
Item number 23.
Pass over.
Item number 24.
this is the case, my lord.
24.
24 minutes. The petitioner is the wife, my lord. She sought the transfer of the civil proceeding from the Judge Family Court, and Judge Family Court Kota to Barampur, my lord.
Let us see what has happened to the notice. Notice on the sole opposite party is sufficient. There is, however, no appearance. As such, the transfer application is taken up for hearing. Yes. You wanted to be, which case to be transferred from where to where?
That is from Honorable Judge Family Court Khorda
To Ganjam.
to Ganjam, my lord.
On what ground?
The ground is that, my lord, it is more than about 200 kilometers, because the present petitioner is residing with his brother at a remote village near Hinjli Cart, my lord.
Near?
Near Hinjli Cart.
Injury cut.
Hinjli Cart. And the difficulty is that, my lord, she has been threatened with direct consequences by the husband, and the husband poured kerosene on her, and she was rescued by some others, my lord. So there is a threat perception to visit the court, my lord. And besides that, my lord, she is a housewife and no means to survive for her survival.
The petitioner has filed this application seeking transfer of civil proceeding number 184 of 2017 pending in the court of learned judge, family court Khorda, to the court of learned judge, family court Berhampur. Prayer for transfer has been made on the ground that the petitioner is residing in a village near Berhampur, which is more than 200 kilometers from Khorda, which is nearly 200 kilometers from Khorda. Further, she has no independent means of income. As such, it would be inconvenient on her part to travel from her village to Khorda to attend the court on the dates of posting of the case. Considering the ground raised for transfer, this court is inclined to accept the same. The transfer application is therefore allowed. It is directed that one.
Diplomatized.
Number 25.
25, 26, your lordships. Your lordship was placed to, my lord, direct the family, law and family judge Cuttack only to give a report. Because during stay operation of the case, my lord, actually the family court
See, Asian resurfacing for key court.
yeah, but it is reviewed.
It has been reviewed. As directed, learned judge, family court, Cuttack has submitted a report stating that the proceeding in the case in question was resumed by applying the principle laid down in the judgment of the Supreme Court in the case of Asian resurfacing of road agency, so and so. As 6 months had elapsed.
And 6 months, my lord, it is continuing time and again. Not that the, my lord, the stay was operating and it was listed and the stay was also.
I am writing whatever he has said.
Yes, I am sorry. I am sorry.
Thereafter, parties were noticed and the matter was fixed for conciliation. Ultimately, judgment was pronounced on 4/12/2023. You have to challenge that judgment, Mr. Mahathir. Now, which
no, madam, there is a judgment of your lordship may take it some other day. I will show you the judgment of this honorable court also. If any restraint order is there and violating that restraint order, something has been done, and it can be said.
No, I have myself. There is a judgment I have delivered. I have ordered restoration of status quo ante. But here in this case, he has applied the law as it existed then. Subsequently, Asian resurfacing.
By that, my lord, just my lord, in the month of April, my lord, judgment was passed. Not
Okay,
that
okay.
by that time, my lord, that is
Okay,
already.
okay. You find out that judgment and you appear in person, sir. Kindly.
Yeah,
Please take the trouble of. Please take the.
I am sorry, my lord, due to my personal difficulty, my lord, my aunt had passed away.
Personal difficulty to ଗୋଟେ word କହିଦେଇଛନ୍ତି ଆମେ ଶୁଣିଛୁ।
ନାଇଁ sir, ଖୁଡି ଚାଲି ଯାଇଥିଲେ ମୁଁ ସୁଧ ଘର ସାରିକି ସକାଳୁ ଆସି।
ହଉ Upon you bring the latest judgment of the
My
Asian
lord. My lord.
we'll see.
Aye.
Learned,
Last time I
Sima.
have filed the judgment of the Lord and Family Judge.
ନାଇଁ ସେ ଦେଖନ୍ତୁ ସେ ରିଜ୍ୟୁମ କରିଦେଲେ ବଟ୍ ବାଇ ଦି ଟାଇମ୍ ଜଜମେଣ୍ଟ ଡେଲିଭର କାମକୁ ନୂଆ ଜଜମେଣ୍ଟ ପୁଣି ଆସିଗଲାଣି ହି ଶୁଡ୍ ହାଭ୍ ଷ୍ଟପଡ୍ ଆଟ୍ ଦ୍ୟାଟ୍ ଅସୁବିଧା ହବ ବୁଝିଲେ ସିନା କଣ ହବ ନ ବୁଝିକି କରିଦେଲେ ଆଉ ସେମିତି ହବ one has to be careful in dealing with these matters କିଛି ନାହିଁ ଜଜମେଣ୍ଟ will be a nullity ଆଉ କଣ କରାଯିବ we will see. And what will be the remedy? Because that that is a different matter altogether, isn't it? All right. Sri Mahapatra, learned counsel for the petitioner, requests for an adjournment. Is this matter next week? Next week.
1 week after your lordship may say. Aye.
Item number
Interim order may be extended. In both the
26 also same. The interim order to continue.
my lord, diplo.
Item 27. तू बड़ा पट्टे रखो ना क्या है कि देखियो बड़ा पट्टे
My lord, it's a transfer petition. My lord.
please use the mic
My lord, it's the transfer petition. My lord's notice has been served thrice. As per the last order, the state was advised to reach the
Yes.
petition number via
state notice
27.
notice जाइथिला
My lord's mother served Korea film and last time notice jaitila, my lords.
Let it be called tomorrow. I will inquire today.
all right as requested by London State Council let this matter tomorrow you find out telephonically you can find out from the local police station whether notice has been served or not yes item number 28 pass over kariya kon kare pass over
This is the case where he has filed a petition for transfer of the case. In the meantime, no stay order was granted by this honorable court. In the meantime, which case the transfer is sought for, that case will reach its finality. And they have filed a petition on that in that court for recall of that order. Your lordship on last occasion asked them to say what has happened to that.
ठीक है जी pass over तक करो because he is not there let us pass it over ଆପଣ ଅଛନ୍ତି କୋଉ ନା ଆମେ ବୁଝି ଯାଆନ୍ତୁ ମିଷ୍ଟର ଆଉଟର ପ୍ଲିଜ these are arguing counsel chair पर
My lord, I was filed for.
you are forgetting justice PC next court two chairs were there
In chair, backside also.
also written ମୁଁ ବି ଆମେ ଲେଖିଦେଲେ ବି ହବ arguing counsel ଯେତେ ଲେଖିଦେଲେ ବି ହବ ହେଲା ଆମର ଦିଟା ଚେୟାର ଲେଖିଦେ arguing counsel
My lord, we have filed IA for set aside of the ex parte order. The opposite party will appear on 20 July. Kindly adjourn the matter for 2 weeks.
fair enough they are always it is open to them to seek recall of that order before the court below
Final orders pass, and as per the direction of the judge family court, I have deposited 5 lakhs in that court. She has not withdrawn it, and fact remains, my lord.
settlement କରୁନାହାନ୍ତି
Settlement पे बसिथिले सब होला जे the expectation is much more higher than the
then counsel
judge family court come to a conclusion after discussion all these things, and awarded rupees 5 lakhs in the event deposit of 5 lakhs, the decree of divorce may be allowed. And in response to that order, I have deposited 5 lakhs before the judge family court, and a decree of divorce has been passed.
then counsel for the petitioner prays for an adjournment let this matter କେବେ କୁ ଅଛି ଆପଣଙ୍କର
28 जुलाई कहउछ
28 ଜୁଲାଇ ଅଗଷ୍ଟ କର 5th ଅଗଷ୍ଟ
My lord.
deeply August. Item number 29.
My please, your lordship. And the petitioner has filed a IA for amendment, my lord.
आइए
My lord.
for amendment
My lord, it was initially filed for transfer of the case to Hon'Ble district, my lord. But since the petitioner is a working lady, she's a police officer, so there is a chances of transfer, and that is a very limited period posting, my lord. So Denkanal is her father's house.
all right
She's seeking for transfer to
IA 158 of 2024. The prayer for amendment. Is an application for amendment for substituting the word Dhankana with Hon'Ble. As in the meantime, as the petitioner wants the case to be transferred to Dhankana instead of Hon'Ble in view of her transfer. Yeah, though. Since the proposed amendment appears to be formal in nature, and there is no objection from the other side, I am inclined to allow the same. IA is allowed. The petitioner is directed to file consolidated transfer application within a week. List this matter on 29 July.
I may request for a stay of the proceeding, my lord.
In the meantime, if any application for adjournment is moved,
Keep the place.
The wife petitioners wants to file a DV case before the JMFC Berhampur, my lord. He wants to transfer the JMFC Soda.
Mr. Mahanti,
My lord.
this is a very interesting thing. Petitioner name is also Das here, the counsel. The opposite party counsel is also Ashok Das.
And also,
You are holding brief from both sides. Yes.
so only ground is that the opposite but one husband is a member of the Ganjam Bar. He appeared in that case. So at least
You are the wife.
I am the wife.
Yes.
22 lawyers had appeared on behalf of the husband. And nobody is appearing for the person was appeared on behalf of the wife. He also withdraw his vocal tremor, his power. Influenced by the other bar members. Nobody has cooperated. Even if the district legal authority has directed to appoint any lawyers, till now nobody is appearing to them. So that's on the ground that will be transferred to Saroda. Where is the wife is living? Only the ground.
No. If the ground is accepted, it will prove that the court is not functioning properly. Neither the court is functioning properly, nor the district legal services authority is functioning properly. I'll call for a report from the family judge.
Yes.
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 My lord, one thing will have permission. The petition at all not maintainable, my lord. In section 407 CRB, my lord. Within the district, one magistrate to one magistrate, my lord, he wants to transfer, my lord. So it is, he has to approach before the sessions court. Thereafter he has to come to High Court.
Here,
But he directly come High Court, my lord, bypassing.
That is the circumstance. Hence of justice.
Nobody
is appearing. Se कौन करेगा? Justice to close this man.
so let us call for a report. Your objection is still valid. I'm not passing any order.
Yes, that is admitted. In circumstances, I am quite sure. Nobody is supporting him. In the power data, she would recommend.
This is Alok Mahanti, Learned Counsel for the petitioner. Forcefully argues that the petitioner is unable to engage a lawyer, as no one from the local bar has come forward has accepted her request to represent her in the case. Stop it. Further, the counsel engaged by her earlier has also withdrawn his power. He further submits that despite approach, despite instructions issued by the District Legal Services Authority, no one has come forward to represent the petitioner. The କୋଉ କୋର୍ଟରେ ଅଛି ଏଟା?
Yes, pending before the JMFC.
Leonard JMFC Rural Secretary COG Barampur is directed to submit a report in this regard. Place this matter on 22nd 29 July. Yes, this order will be communicated to the court below. Because sir asu
आगे
sir asu tapo
खाली रिपोर्ट आसु ता माने मो ऑब्जर्वेशन टा केतल दिया हबो आइटम नंबर 31 31, my lords, I am the petitioner in this transfer petition. Your lordship, on the last occasion, the counsel for the opposite party had sought time for filing of the counter affidavit. Your lordship.
What counter here? Gauri Patra versus Babula Patra. You wanted to the case to be transferred from Bhavalipatna to Bargar?
Yes, your lordship.
Yes. What is your objection?
My lord, only objection is, my lord, regarding the territorial jurisdiction. That is, my lord.
How many appear virtually? The petitioner wife seeks transfer of.
This is civil suit, my lord.
Civil suit.
This is a civil suit.
Yes, ma'am.
I mean marital proceeding.
No, my lord.
How?
This is a civil suit relating to immovable property.
Relating to immovable property.
Yes, ma'am.
Transfer of
Declaration
civil suit number 26 of 2023 from the court of Leonard Civil Judge Senior Division Bhavanipatna to the court of Leonard Civil Judge Senior Division Bargar.
Yes.
Therefore, transfer has been made on the ground that the petitioner has 2 children and is residing at Bargar without having any source of income.
Yes.
As such, it is proving difficult on her part to travel to Bhavanipatna to attend the court on the dates fixed of in the case. You don't have to appear every day. You don't have to appear every day. Your lawyer can appear.
Your lordship, multiple cases have been filed in Bargad and the parties are living in Bargad itself.
Learned counsel appearing for the opposite party opposes the prayer for transfer on the ground that the petitioner, this being a civil suit, the petitioner is not required to physically appear on each date of posting of the case, as she is already represented by a lawyer. Stop. To the above, it is submitted by learned counsel for the petitioner that several other proceedings are pending at Bargar.
Yes, sir.
And that the parties are also residing at Bargar.
Yes.
Taking into consideration all the above facts, and particularly looking at the convenience of the petitioner, who is a lady with 2 small children, this court is inclined to take a lenient view. The transfer application is allowed. It is directed at so and so. The court below shall not insist upon the personal attendance of the parties unless absolutely necessary.
Great.
My lord, one line that the property is situated at that the property
So
my lord, that is
So-
my contention, my lord.
so what? So what? No, the court, High Court has the power to.
Yes, my lord.
Great.
Right. Lord, the petition has a prayer for transfer of CP number
736 of
Anybody appearing for the opposite party? Mr. Ajit Roy was appearing?
My lord, I'm appealing for this, your lordship.
Yes.
Yes, ma'am. I'm there for the opposite party,
Yeah.
lord.
from the court of the learned judge, family court, Bhubaneswar to the learned judge, family court, Jajpur, because the wife is staying at Jajpur. And while two other proceedings are also there pending at Jajpur. One execution proceeding under section 125 CRPC. And another proceeding, well, the DV case, that is not in the court of the learned judge, family court, but in the SDJ.
SDJ.
Yes.
Yes, what do you say?
And the distance is, my lord,
yes.
Lord, there are no children. This person is a working man living with his old ailing parents at Bhubaneswar. The marriage was there done at Bhubaneswar, and it is an admitted fact as per the petition also, your lordship. I leave it to your lordship, my lord. My lord, we are willing also to pay the cost in case the girl travels. And my lord, she need not
Well,
be.
you can also appear through virtual mode, and your personal address will not be.
Make a submission more on that because I bowed down. But my lord, he is a working man, but the girl is unemployed. So we are willing to pay her the cost of her travels just for the convenience, and we are already
What do you
paying.
say, Mr. Lanka? He's willing to pay your cost of travel.
that is like one of the grounded life risk is there, my lord, because once an attempt was made, that is also
Call it, I'll allow it. The petitioner wife seeks transfer of.
My lord, may I just request your lordship to kindly grant us that liberty that your lordship was wanting to give it to the wife, my lord.
Yes, that virtual mode, though.
Yes, your lordship.
Yeah, that will obviously be.
Yes,
Transfer of CP number 736 of 2023 from the Court of Learned Judge, Family Court 1, Bhubaneswar, to the Court of Learned Judge, Family Court, Jajpur. Prayer for transfer has been made on the ground that the petitioner is residing at Jajpur without having any source of income. Secondly, two other proceedings between the parties are also pending at Jajpur. Sri Saurav, Learned Counsel appearing for the opposite party, opposes the prayer for transfer on the ground that the opposite party is employed, and therefore it would be difficult on his part to travel from Bhubaneswar to Jajpur to attend the court. Considering the submissions and the relative inconvenience that may be caused to the parties if the proceeding is allowed to continue at Bhubaneswar, this court feels that it would be more inconvenient to the wife than the husband. As such, this court is inclined to allow the prayer for transfer. It is directed that such and such proceedings be transferred. Right? It shall be open to the opposite party to seek permission of the court to appear through virtual mode. Further, the court below shall not insist upon the personal appearance of the parties unless absolutely necessary.
My lord, just two more submissions, if it can be recorded, my lord. That old ailing parents of the opposite party, and that we are already paying her the cost.
Further, the opposite party is also required to attend to his old and ailing parents who are residing with him. Yes.
I'm grateful, your lordship.
We have to give one more opportunity. Notice on opposite party has been served through his father. There is, however, no appearance. This court therefore feels that one more opportunity should be granted to the opposite party to appear. Lest this matter out here. On 5th August.
Report showing that they did not track.
Tracking report अच्छी दिखी देवा. Item delivered. My lord, oh, you are appearing. Very good. The Pramod Kumar Nigam, advocate and associates have entered appearance for the opposite party by filing Wakalatnama in court. Same be kept on record. Their names be reflected in the cause list as well as in the brief. List this matter. Any chance of mediation?
No, Your Lordship.
No.
Maintenance case is pending in court.
All right. List this matter for final disposal on 5th August. Is there any interim order?
Your Lordship, no interim order. Just Your Lordship, whenever the time person will be moved.
All right, adjournment.
Your Lordship. 33 interim order का 15/7
Stay thila na adjournment thila?
adjournment पे
Sir, kete item?
33
33 रे भी interim order से adjournment कर दे.
5 से 8
Adjournment कर दो.
हमसे सर adjournment टा जितने नहीं आप
Adjournment. Kahi mu कोच mu जाने नहीं.
आगे
May I please, my lord. Lord, I am for the petitioner.
You are for the opposite party? Yes, my lord. Mr. Padhi? Mr. Padhi, you are occupying the arguing council's chair.
I also requested to him, but he suggested.
नहीं काली हमें लगे लिखित होते तो काली हमें सकाल लिखा ही तो देखिए arguing council chair अपने state council chair. Yes.
My lord, I want to kindly refer the matter to mediation center for.
What is it? I am agree. Yes. In course of hearing, it is stated at the bar that the nature of the dispute is such as can be attempted to be resolved amicably through the process of mediation. Let the records of the case be placed before the Odisha coordinator Odisha High Court Mediation Center. You shall appear pursuant to. Yes, my lord. Please. List this matter. August last adu karo.
12th August.
How do you go?
29th August.
29th August. Published. In the meantime, IOC further proceedings in CP number 127 of 2024 pending in the court of learned judge, family court Jagatsinghpur shall remain stayed. Dako Yakub. Balaram Gudak. Yes, 36 Dako.
Notice written undelivered.
Postal tracking report is in. Oh, undelivered.
Yes. Rest notice.
Addressee can't be located. You are appearing in Chennai?
36.
Yeah.
I am appearing for respondent.
Yes, opposite party. Very good.
Chalo.
Second of the
Sorry, my lord.
Oh.
That hearing.
You are appearing.
37.
So take notice again. Notice on the opposite party has written undelivered with the postal endorsement. Addressee can't be located. Hence, return to the sender. Learned counsel for the petitioner is directed to take fresh notice, furnishing the correct address of the opposite party. Such notice shall be issued by speed post, fixing a short returnable date. Requisites be filed by day after tomorrow, peremptorily. List this matter August.
ଭାଇର ବାହାଘରଟା ଅଛି
Fresh file କରିବେ
ପୁଣି ଆସିଲା ବେଳକୁ ଏଟା 17 ତାରିଖରେ ତାର ଅଛି ବାହାଘର ତ ରିସେପସନ
ବାହାଘର ସରିଲାଣି ରିସେପସନ ଅଛି
Learned counsel for the petitioner submits that he would file an application for interim bail and requests that the matter be taken up tomorrow as the petitioner's brother is scheduled to get married on 17th.
ବାହାଘର ସରିଲାଣି ରିସେପସନ ଅଛି 17
ତାରିଖ
ଗତକାଲି ସରିଛି।
ଖାଲି ଲେଖନ୍ତୁ ସେତିକି ଲେଖନ୍ତୁ ଆଉ କିଛି ଲେଖନ୍ତୁ on the ground ଟା ଲେଖନ୍ତୁ release this matter tomorrow. You file or you file it at the court to file period in 2020 ହଁ ଏଟା file ହବ 24 ନୁହେଁ. Yes.
May I plead, Lord? Well, Lord, this is the second round bail application. The earlier bail application of the petitioner was disposed upon 24/11/2022.
ଆଉଥରେ କହିଲେ
SC/ST.
SC/ST?
My lord. Appeal is there, notice to opposite party requirement.
They are rejected on the ground of dying declaration in which he clearly implicated the petitioner. Ground rejected.
Dying declaration of the not the deceased.
This is the order dated 24/11/24.
Anyway,
Yes,
filed it.
notice to go, CST is there.
Let an extra copy of the appeal memo be served upon Learned State Council.
Just now I am serving.
An extra copy of the appeal memo has been served on the State Council in court, who shall cause the same to be served upon the informant/victim through the IAC of the concerned police station, indicating that the matter shall be taken up for hearing on court jaga.
This is Talcher, Hon'Ble police station.
Tale
Okay, examiner.
on 29 July.
My lord. High witness.
Release this matter on 29 July.
In the meantime, the witness has been examined. Let the copy of the deposition may be submitted.
Item 40. Password. बहुत अजीब password. बहुत password.
Extension of first time extension of interim bail. Extension of interim bail first time.
Now the film. Every alternate day, other also get covered.
What instruction have you obtained?
Extension, my lord, your lordship was condition fixed, your lordship. Every alternate day will appear at yes, but as per my instruction from the IAC, he is not appearing.
He is not appearing.
No, man.
When are you going to? When is the date of surrender? Kali. No. If you are not complying with the order, I will not. No, you take telephonic instruction.
I have taken telephonic instruction today morning.
No, I will reject it. No, Mr. Jana. Court's order is violated means no. Land State Council informs that the petitioner has not complied with the conditions imposed by this. Written though? ठीक है अपन surrender कौन तो written से anyway. You surrender tomorrow. Land State Council is directed to obtain instruction in writing from the IAC of Plant Site Police Station as to if the petitioner has complied with the condition imposed by this court in order dated 21/6/2024. In the meantime, let the petitioner surrender. Yes. Release this matter on 22nd. On 22nd, next week, next Monday. Yes. बसन खसिगले कौन करिया बसन नहीं जी नॉट 42
May I pray? Offenses under section 419, 420, 465, 467, 468, 471, 120B, and 34 of IBC, and read with 66D of IT Act. The present petitioner, Muhammad Iqbal Hussain, is not named in the FIR, my lord. So far as the FIR allegation is concerned, my lord,
Trupti Ranjan Das, SI of Police, STF, CIDCP, Odisha Bhubaneswar, lodged FIR on 12/5/2023. He alleges that on 11/5/2023 evening at about 8 p.m. he received credible information from his source to the effect that one Pathani Samanta Lenka, who is the main accused, had been a member of one Facebook group named and styled as Free Recharge Box, where he, along with approximately 1 lakh persons, are the members of our country, as well as foreign nationals. My lord, the work of the group is to share OTP as well as mobile numbers to the group members and made illegal transaction.
In the previous case, you had prepared a pictorial depiction.
Yes, he is coming under similar footing as Pathani Samant Lenka and one Abhijit Sanjay Jambure Desmukh. Their bail application has been rejected. As per the direction of one Hamid, who is the Pakistani HI, he has received, my lord, 500 and rupees 80 from Abhijit Sanjay Jambure.
So we can consider that, but you had prepared a chart. Do you have that chart? Mr. Mishra had prepared.
Mr. Mishra, I think.
Get that chart.
Yes, sir.
The State Council is directed to obtain further instructions in the matter, particularly as regards the involvement of the petitioner in the alleged occurrence. List this matter next week.
Only allegation je 500
he is coming under
Jambure account ru aschi.
500 Tonkata is not important. The link with the Pakistan
on that account.
ISI is important.
His bail
କିଛି
application
ନାହିଁ
has been rejected.
ମାନେ ଇଏ ମାନେ only ଏ ୟା କିଛି ଆଣ୍ଟିସିଡେଣ୍ଟ ନାହିଁ
Next
ୟାର
week.
ମୋବାଇଲ ଟାକୁ ସେମାନେ କଣ ସାଗ ଦୃଷ୍ଟି ନେଇକି ୟୁଜ କରି କରୁଛନ୍ତି
ଦେଖିବେ. We'll see.
ରହିଗଲାଣି 1 year ପାଖାପାଖି
ହଁ, next week ନବା ପରା.
May I please? The deposition I have already supplied to court and honorable court and the state also not. Victim is already examined. And paragraph 2 and 3 in chief, that one Prakash Santal and Saroj Khosla is the prime accused, my lord. Some role attributed, his name is Krusto Khilo.
Yes, ma'am. Case judge is there. We wanted to see the 164 statement. Case judge रे किसी देखने.
What is your name, Mr. Pandey?
Krusto Khilo, my lord.
Krishna Khilo.
Yes, my lord. And lordship granted one of the court is Saroj Khosla because his name is not in FIR but subsequently come in deposition, my lord. Serious allegation against one Prakash Santal and Saroj Khosla, my lord. The, paragraph 2 and 3, my lord.
Allegation of sexual
assault is not there.
Not against.
This present petition. So lordship wanted to see the 164.
ସେ ପ୍ରକାଶ ସନ୍ତାଲ ଉପରେ direct allegation. We can consider, Mr. Mishra. The petitioner is in custody since
9/9/21.
9/9/2021 in connection with such and such case. The prosecution allegation is that the petitioner, being related as uncle by village courtesy with the victim, lured her to Koraput on the pretext of meeting her husband, who was lodged in jail. They also took some money from her, and after arranging a meeting with her husband, they took her back to the village on a motorcycle. But on the way, the petitioner facilitated the co-accused Prakash Santal to commit rape on her. Insofar as the petitioner is concerned, the victim has not made any allegation of sexual assault against her, either in her statement recorded under section 164 of CRPC or in her deposition before the court, a copy of which is available on record. The main allegation appears to be directed against co-accused Prakash Antal and Saroj Khosla. So, the role of the petitioner is that of a facilitator. Stop. Considering the nature of allegations, the period of detention of the petitioner in custody and the fact that the victim has already been examined, I am inclined to take a lenient view. Let the petitioner be released. Each chapter. Pass over.
Number 45.
May I please? Present petitioner who is inside the custody since 27/9/2020. Even though your lordship granted interim bail, he has never been violated any condition in time. Yes, sir. I have on last occasion I have submitted with your lordship. In time, yes, sir.
Yes.
Status report ଗୋଟେ ନେଇ
କଣ ହେଇଛି?
ଆଇଓ ଇନଫରମେଣ୍ଟ ଆଇଓ ବୋଧେ ଅଛନ୍ତି ଏକ୍ସାମିନ ହବା ପାଇଁ ଷ୍ଟାଟସ ରିପୋର୍ଟ ଗୋଟେ ନବ
Like ଚାରିଟା ସାକି ଯାଇଛି।
Out of
ଲେଖିଛନ୍ତି କିନ୍ତୁ ପାଞ୍ଚଟା ସାକି।
How many witnesses are to be examined?
20 out of 24 witness, my lord, charge sheet witness. My lord, see, I can see. The matter of witness, that is the infant and the IO have not been examined.
24, yes.
24.
Yeah.
It has been reflected that infant and IO have not been examined till yet. That is the, but my instruction, the independent witness or the witness, they have been examined.
Use quantities from Andhra Pradesh.
In time, he has surrendered. Your lordship, even though granted liberty, he has never violated any condition.
811 people.
27/9/2021. I am inside the custody.
I've already granted you interim bail.
Well, in time, yes, on last occasion, my lord, I have submitted because your lordship, so that 10 more days, I will consider. That is prior to vacation. Others have been granted bail because two vehicles they were running simultaneously. Other person they have been granted bail because less quantity has been, and both the contraband article has been taken into consideration. That total is that much. I have got that other co-accused person's bail order. I have contacted that. नहीं आरंभ महत्व अच्छी
Whether on each date of trial, whether he is appearing or not, his conduct, lordship may.
He has surrendered. It has been
surrendered.
दंडपति जानी and up.
Sir, 52 kg इस तरह.
हाँ, से इतर दीटा का मिस्से की करते हैं 8 से. दीटा गाड़ी जाता है. 52 kg
किसी नहीं.
No, नहीं पता. Back पर कभी नहीं.
आगुर दिलन.
Yes. And the conduct of the petition is so. He has never violated. He has on the right time. He has surrendered. Not the co-accused person. Your lordship can see the affair. Seven persons they have been named in the affair.
The petitioner is in custody since 27/9/2021. Not regular.
Well,
Regular or
no, regular. No, say.
In connection with such and such case. The petitioner was earlier released on interim bail for a period of 3 months. As per order passed in BLAPL number 5784 of 2023. He has surrendered to custody in time without violating the conditions imposed in the order granting bail. it is submitted that only 4 out of 26 witnesses have been examined. The petitioner, being a resident of the state of Andhra Pradesh, is finding it difficult to attend to his family needs. It is appropriate that he may at least be released on interim bail again for some time. The state council has opposed the prayer. Considering the submissions and the fact that the petitioner has not misused his liberty granted earlier, I am inclined to take a lenient view that the bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 3 months.
Oblige. Object.
Next week is paid for.
Cultivation of home plant, my lord.
Yes.
Cultivation of home plant, my lord.
Implant.
My lord. Accused person already religion.
Very serious, Miss Nanda.
My lord.
Very serious offense.
Ajay.
2000
jail समझ लो.
मैं भूल कर दीजिए, रिकॉल कर दोगी. सुनो दो.
मत गाली देवे.
गाली दे क्यों करो? That is a professional hazard. You have to face it. You are creating that product. Arun Maji.
Similar.
Same order.
And vigilance. Particular lawsuit will also granted to work with similar.
Court is there, sir.
My Sima Behra lawsuit granted. Basing upon the PM report of lawsuit.
No, this has to be, I think we have to examine. Very serious offense.
Earlier
rejected, madam.
Earlier rejected.
Earlier rejected, but at that time the PM report was not there. And
no, you obtain the CD.
Yes, there is there.
Call for it.
Find out.
No external injuries, my lord, and PM report viscera is pending, my lord.
So how did he die?
I have taken some
poison.
Poison.
He has committed suicide by taking poison. The allegations are that 3 persons, the Prashant Behra, Sima Behra, and President Hari, they have dragged him to from his house and assaulted by the head injury sustained by female.
The prisoner
Subsequently, FIR allegation.
The petitioner, her husband, and one Hari Behra dragged their son Ajay Muduli to the road from his house and assaulted him by means of iron rod and bamboo stick, causing bleeding injury. Is there any no injury?
No.
So this part appears to be false.
Yes.
The Ghosari Gandle, Mundar Marile.
Charge sheet into file is 323, 450, 294, 506, but there is no injury.
If the postmortem report doesn't say any injury.
Yes, ma'am. Postmortem report is 9.
There is no mechanical injury in any form detected on the body of the deceased.
Yes, ma'am. I have the injury report.
Considering that also.
Yes. Same order.
Okay.
Same order.
One week after.
1 week after.
Interim order to continue.
1 week after the date karo.
29.
This matter on 29th June, 5th August. Thank you.
Interim order.
Thank you. कौन मुझे देखे है जिनसे तो
300 से दे
उनसे देखे वाले कौन असुविधा है
Sen ସମସ୍ତଙ୍କର first or second year ହେଇଛି other co-accused persons and previous injury and
previous injury ଅଛି ତ
ଦିଟା ଅଛି
ଏଟା he is involved in a murder case, he is in custody, my lord.
No, but I have not said that it will be considered only if the injuries are simple, that is not there. So why don't you take that order?
এটা হবনি আসু চার্জ শিট হই গলে সরেন্ডার ওই চার্জ শিট
Is I bhabi lije. Let it come on 29 July. Interim order to continue. Item 50 pass over. Pass over.
Modification of order. 7 either condition every alternate day re jota hai weekly. अन्य मानकर सब every Sunday ହେଇଛି ସେଇ order ଟାରେ ଖାଲି alternate day ହେଇଛି।
और कौन ହେଇଛି?
You shall appear before the IIC Rambha police station on every alternate day।
ଏଟା ଗୋଟେ ହେଇଥିଲା ଗୋଟେ ଚେଞ୍ଜ ହେଇଥିଲା
ସେଇଟା ଭୁଲେ
instead of for modification is allowed you लिखिबे instead of appearing before the IIC of Rambha police station on every alternate day at 10 a.m. He shall appear on every Sunday at 10 a.m. All other conditions remaining intact.
extension
2 weeks for the time.
23, my lord, 3 FTST Annex 2 is the similar order of the other petition. Yes.
Same order.
Before your lordship, there is a noting your lordship.
এটা কেতে গলা 53 গলা 53 গলা সেম yes please
Yes, lordship. There is a noting. In the noting, it will written as here.
but correction be made accordingly এটা আমারে নিজে করব correction টাকে বলবো নোটিং তো দেখি yes item 55
For restoration, my lord.
restoration will be allowed subject to cost of rupees 1000 because of your mobile Mr. Author
I will take some. My entire body is not functioning.
টাকা দিবে তো কিছু
Neuro problem ଏବେ ହେଲା ପରେ ବହୁତ ମତେ ଅସୁବିଧା ହଉଛି ବହୁତ ଅସୁବିଧା ହଉଛି
କଣ dismiss ହେଇଥିଲା what was dismissed read petition
my lord
dismissed by me restored yes এই hearing part টা রাখি দিও খালি এই যে criminal part টা রাখি দিও will go to the other yes
54 মানে
আয়া 54 sorry 54 item 37 pass over item 37 দেখা আগে criminal matter টা সরে যাও will go there so that it will be easier for him to attend the other counsel will again
Appeal, my lord, your lordship granted interim bail.
what is this why appeal SCST
No, conviction matter.
Oh, conviction.
For a period of 10 years. After hearing, your lordship granted interim bail. I have filed a miscase for extension.
that interim bail is still continuing
Yes, sir.
thoro continue ହେଇଛି ପରା ଆଉ କଣ
Price granted.
Hearing କରିଦେଲେ ବି ହେବ ଖାଲି only examined, my lord, victim and the judgment was passed. No medical officer was examined. That's why your lordship granted interim bail. Your lordship extend the interim bail and posted for hearing, my lord.
I cannot hear it the problem
This is the Honorable Chief Justice has directed.
directed only the bail matter to be heard otherwise I can hear it
আসছি এইটা ଆପଣ শুনিବେ ବୋଲି আসছি
to be consideration and nomination of appropriate bench to take up the present IA number so and so arising out of ସେଇଟା କେବଳ ମୋ ପକାଉଛି chief justice କର
ତାହେଲେ extension ଟା
ସେ ଯୋଉ previous extension ଟା ଯେମିତି ହେଇନଥିଲା ହେଲା
copy in course of it. Tomorrow is the
କାହିଁକି ଆଗରୁ ଫାଇଲ କରୁନାହାନ୍ତି
ଫାଇଲ କରିଥିଲି ଆସିଲାନି ଗତ ୱିକ୍ ରେ ମେନସନ କରିକି ଆଜି ଆସିଲା
ହଉ in course of the
Extended for.
yes
Extended for
say 4 months
4 months.
criminal appeal ଟା ତ
Item number
40 none appears on repeated calls ଏଇଟା ଏଦି କରିଦିଅନ୍ତୁ correction be made accordingly ଏଟା correction ଟା କାଇଁ ଅଛି ନିଜେ କରିଦବା yes
44.
44 none of ଆଜ୍ଞା
54
ଆଜ୍ଞା ଟିକେ 44 ଗୋଟେ ଚାଲିଛି ସେ ମ୍ୟାଟରଟା ଟିକେ ମୁଁ ଆପଣ ନୂଆ ପ୍ରାକ୍ଟିସ କଲା ଭଳିଆ ହଉଛନ୍ତି ମତେ କିନ୍ତୁ ଆଶ୍ଚର୍ଯ୍ୟ ଲାଗୁଛି ଆଜ୍ଞା। Why are you so worried, Mr. Manjudhar? I don't understand. I will take up your matter. Why are you worried? Why are you so much worried? I don't understand. Item 44 ଡକାଲମ ସେଟା ଟିକେ ଅର୍ଡରଟା ଡାକିଦିଏ। All right. None appears on repeated calls. Place this matter 1 week after.
Item number 50.
Item 50.
May Lordship last to my lord for the case record, and here is a case, my lord. The petitioner got married to victim, my lord. And in connection with the co-acute bail order running page 13 and 15, paragraph 4, my lord. Running page 15. London State Council has obtained instruction from the IO that though the victim had not been rescued as yet, and it has been confidently ascertained that she had married the principal petitioner, and both them are residing peacefully. In so far as the petitioner, I am praying the directive to produce for 164 statement.
Let him.
State Council is direct.
With age and
What is it?
marriage certificate.
Marriage certificate कहाँ आपा?
Let him produce the victim.
It is submitted by the counsel for the petitioner that the victim and the petitioner have in the meantime married, and that he shall produce the marriage certificate.
Already annexed. Annexed.
Marriage certificate नहीं?
Annexed already annexed.
अच्छा 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 हाँ तो खाली इसे लिखो दो। Learned State Council is directed to produce the statement of the victim recorded under section 164 of CRPC. Release this matter on 22nd, 29th July.
He will produce matter because not yet rescued till date. As per.
हेला अपन करी जो सेम तो हबो किंतु
Yes.
Yes.
Interim order.
Interim order to continue. 51 non appears on repeated calls. Release this matter 1 week after. 54 खाली correction टा.
Correction does I bring the lordship action, son. An execution case has been filed. After the lordship direction, we have given the cash draft of rupees 35,000
Yes.
along with that. So they have filed an execution case for no one thing, no coercive action shall be that thing will be added. Because execution case has been filed, we have paid 50,000 and matter has been sent for mediation center. That is in the order. And another process.
But there is an interim order in your favor.
That is stay of further proceeding is a transfer case. But an execution case that they have filed in the meantime, and someone has been issued. So
for that you will have to file an IO. You have to file an IO. Otherwise, unless you file an IO, how can I pass that order?
That is another case, my lord. So no, only pay for no coercive action.
No coercive action केମିତି ହବ? Already interim order ହେଇଛି ନା?
For stay that is transfer case टा जो हवा पे ହେଇଛି जो maintenance case टा stay ହେଇଛି. But in the MAT case, they have filed an IA for interim order was passed for interim maintenance.
So we are not on that MAT case.
We are not that on MAT case.
So how can that order be passed? That execution case arises out of the MAT case.
I am paying also on the maintenance of that case. In this
Maybe, but how can this order be passed in this case?
only pay no coercive action.
କେମିତି ସେଟା ହବ? Technically ଆପଣ ବୁଝଉନାହାନ୍ତି ମତେ କେମିତି ହବ? This case arises out of CP number 736 of 2023. If any coercive order is passed in this case, then yes, this court can pass that order. In any case, the proceeding has been stayed.
Yes.
Proceeding has been stayed. Now you are apprehending that that execution case will be in that execution case a coercive order will be passed against you.
से कोतले जो पहला जो दिल्ली 50,000 टंका से जो इंटरिम मेंटेनेंस टुवर्ड्स से पे मु कोछि जे कि नो कोर्सिव हे गेल मु से ऑर्डर सीट ने देखे देबे सो
No coercive action, this will not cover that case.
only coercive.
No, this will not cover that case. Try to understand, sir. That is a separate case. You have come for transfer of a different case in which the matter has been stayed.
Yes, sir. But I have paid the amount so far as the interim maintenance of that case is concerned.
And I don't understand how can I pass such an order? It is just not possible. How can I pass that order? CP number 736 of 2023 has been stayed. Correct. There is a maintenance case.
CRP 62 by 2023.
आपको स्टे हिची कोटा आपण ट्रांसफर पे आस्ते CP number 736 of 2023 has been stayed.
CRP number 62 by result please. Last part. Paragraph 5 of the order. Proceeding CRP number 62 of 2023.
It item 54 though.
54.
TRP number 35 of 2024.
24.
35 of 2024.
সেটা উপর লেখা আছে 2017.
Sir, it's no.
Yes, sir.
Now you want you have filed this case for transfer of which case?
Transfer of my lord CRP case number my lord 62 of 2023 my lord. From Judge Family Court that Gunso to Judge Family Court Bargad.
Sir, please come to your prayer.
Yes, my lord.
Call the page.
Can transfer the case of CRP case number 62 by 2023 pending the Judge Family.
अरे आउट को फाइल दी दी चिंता बते बुझलो हैं फाइंड आउट दिखे तार हार्ड फाइल दलो ये डिफरेंट फाइल ऑल टुगेदर ସେଇଥି ପାଇଁ ସେ ହେଇଛି TRP CRL instead of TRP CRL 35 of 2024.
Order sheet रे लॉर्डशिप में पे order sheet पे तो ऊपर लिखा जायतला 2000 रे
This is wrongly मैं देखी कि we will bring the which is your matter?
TRP CRL 35 by 2024 mile.
ସେଇଟା ଆସିନି
In the order sheet it will be written as 2017.
No, I'll see and pass order appropriately. देखिए yes some other case has been here. So in this CRP number 62 of 2023,
Yes, fine.
you are apprehending that some coercive order will be passed. That execution case relates to which case?
Relates to my MAT case. I have annexed in that
अच्छा सेटा CRP सहित केमती ताले
এই document ମୁଁ ଏଇଥିରେ annex କରିଛି.
आपण annex करले मध्ये आपण ट्रांसफर କରିବାକୁ ଚାହୁଁଛନ୍ତି ଆଉ ଗୋଟେ case सेटा stay ହେଇଛି execution case ଟା is connected with some other MAT case. How can that be stayed here?
ନାଇଁ that state ଟା ଠିକ ଅଛି. ମୁଁ କହିଲି no
ସେଥିରେ coercive action ଟା କେମିତି ହବ ଆଜ୍ଞା?
ପଇସାଟା ସେଇ case ରେ ଦେଇଛି.
ने ଦେଇଛନ୍ତି ଯେ କେମିତି ହବ ଆପଣ କହୁନାହାନ୍ତି ମାନେ you give me the handle I will pass that order. It is just not permissible to pass such an order. It will be completely illegal. This order by itself is enough. If you show that the matter has been sent to mediation and you have paid this amount, so obviously you file a petition for stay or to keep the execution case in proceeding pending proceeding in abeyance till the mediation is over. No, 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 yeah. Yes.
Item 51.
Yes?
Item 51. Sir.
51? Yes. Item 51.
The petitioner earlier in bail mallet, 350 or 394 mallet. Subsequent charge sheet added 364 mallet. That's the higher offense mallet. I have approved this on report.
You are on bail.
You are having bail for the
Regular bail.
Regular
bail is এটা হবে না আপন কইছি হ্যাঁ
Then he has to surrender as per the particular.
Surrender mallet I will bail bar.
No, so anticipated bail will not be maintainable. Anticipated bail will not be maintainable. Anticipated bail will, Mr. Naik.
Lordship judgment also I have gone through the.
So my judgment has got nothing to do.
That is 438.
438.
Anticipated.
So you are on 439.
Mallet.
You are on 439 bail, custody bail. So how can this order be passed in once you have gone to custody and been released on 439, anticipatory bail application goes. There is no apprehension of arrest.
And
At best,
bail has been granted on 21. But anticipatory bail here he has filed on 23 withdrawn by knowing all the facts. Also he has not raised any.
The lordship has read the anticipatory is not maintainable. Lordship has view as that. Subsequently, the argue that matter of procedural matter that argued before lordship matter. I waited for that period. Subsequently, I filed this. Or I thought that the anticipatory is maintainable. Subsequently, after the judgment, the entire if the acquittal is anticipatory bail, then
Some higher offense added, so lordship considered.
That is, but that is
so how many?
only lordship. Even lordship, I surrender.
No. How can you even make such a submission? I am surprised. It is not even maintainable at all. How can you make such a prayer? You can seek indulgence of the court by filing another application under 439.
Or modification before the session judge.
Before the session judge, you can modify it, saying that the bail order granted in respect of these offences should also cover the offence under section 364. But not an anticipatory. Just not possible. Yeah, withdraw kar do. Permitted to withdraw. Yes. Item? Password hold up. Item 17. When do you want? Item 17 kilo karo. 2016. All right. List this matter on Sukravar 12th. 19th.
19th.
List this matter on 19th as per for. Yes. Item 10. Is it pattern?
Yes.
What is this matter?
The case is my services were terminated. I approached the tribunal, the regional director of the appellate authority. I was directed to be reinstated in service in my former post. And but I was not allowed for some time. But in a later date, I was allowed to join by the management. So when no payment was made to me in the matter because I was on trade, an order was passed because you are on trade, you will not get benefit. That order of the respective school I challenged in the tribunal. The tribunal passed an order. No, you pay him the benefit of block grant in the on trade scale of that because my initial appointment was of year 1992. The rule with regard to training come in 1993. That was the round. The tribunal's order was confirmed. There is no challenge to that. So now in annexure 2, annexure 1, the circular inspector of school, that is now the DO, has directed me to give a fresh joining report. And accordingly, he has approved my service on 20 with effect from June 2010.
He is hereby allowed to join in the school immediately to be entitled to get
Yes,
employment.
that is the. Now, I only pay in this case. Yes, from 28/6/2010, he has paid me the salary. But as per the direction of the tribunal from 1/1/2004 to 28/6/2010, no payment was made. And in the meantime, I became trained from 2014. So I also prayed that yes, my trade scale is to be given with the revision and all these things.
Can you please
Argument was made because the last time all these what I have stated, these are the facts on record. What argument my friend Mr. Patnaik was there on the other day he has raised because this annexure 1 I have not challenged, I will not get it in the Secondly, he says that against that order of the tribunal, they filed an FAO. And FAO was disposed of because this order was passed. Annexure 1 order was passed because it is stated that the order has been complied with. He has taken the exception to the submission by placing that order. Mr. Das submitted that the order has been complied with. That means the order has been complied with. That means as if I have got the benefit from 1/2004 to 2010. And that is why the order is not to be. Now, whatever he has given, it has been complied with. That is the submission. My responsible submission without quarreling with him, what I have done actually, I have taken step by filing IA for modification because it is partly compliant, not fully compliant. That part is there. Direct of that also, no order has been passed.
You file an IA, it's not there?
No, it's not there. It's not there.
FAO
अच्छा FAO रे
FAO जो लिखिदेले जे as submitted by Mr. Das लेगा partly comply कोर्ट लिख देला तो verify करनो he is taking advantage of that, saying that since you have stated that the order has been completed, now how could you claim that benefit from 2001 to 2000? This is a hyper technicality. But my response submission is, his own order is that you should join and you get it from 2010. Is there a case that we have paid you from?
No, it's not a question of hyper technical. It will stand as an estoppel. Will it not be an estoppel?
There cannot be an, with due respect, my lord, there cannot be an estoppel against a law. Law of the tribunal is the order of the tribunal is the law. Tribunal says I have to get it from 1 or 2004 in alternate scale of pay. Is it the case of the government that they have paid it from 1 or 2004? Maybe in a lesser pay, higher pay. It is their case I have paid it from 2010. So how could it be estoppel? Maybe a statement to the court. But how did I estoppel in true sense? But I have taken step. Therefore, I have taken.
The question is, if irrespective of the order of the tribunal, if the party is satisfied with whatever the government has given, and it is up to the party to challenge. The party decides not to challenge.
By that date, it was in 2023. But by that date, this case was pending.
True. But
that is always.
No, Mr. Das.
Subject to the result of the case, you will argue in strict sense. So my submission would be, because I have taken steps there.
No,
so
please.
These arguments are not, but if you argue.
Please bear with the court. The thing is, it can be an estoppel by conduct.
Yes.
On academic point of view, it can be an estoppel by conduct. It's not that easy because even though tribunal has passed an order in my favor in a particular manner, and I don't accept, I accept it. I decide that I'll accept it. End of the matter. And tomorrow I can turn around and say that I'm challenging.
This case was pending by that. The present case.
That's a different matter.
That is the matter. That is the matter. This case was pending.
All right.
I have taken step, therefore, because that has not been listed, it will be listed. I make a mention because now FAO is taken out only Friday in a weekly list. So supplementary list for that.
That's all.
That will be there.
So that will be decided by that court.
But that clarification will, whatever the now this, I say it is hyper technicality, that will, I think that will set at rest with the facts. But in a fact, before this honorable court, while sitting, hearing a writ petition in 226, when the facts are clear to the court that yes, I am to get employees to get the benefit from a particular date as per the order of the tribunal, and their own conduct they have not paid it from that date, they have paid it from other date. And moreover, I have completed training qualification. Forget about that part.
Same part date
again.
You were appointed?
Who Boyanever appointment heli. My lord, good. 15/7 Boyanever join police. 30/5 Boyanever appointment.
Join.
Again, 15/7 Boyanever.
Untrained.
Untrained, yes.
Yes. Then?
My services are terminated, therefore I filed appeal 65 of 2000.
When was it terminated?
Termination, that is prevention. 7/9/2001, I was terminated.
Anyway, that has been set aside, na?
Yes. 7/9/2001, I was terminated.
We treat it as termination.
Yes.
Because it amounts to termination, doesn't it?
Yes, madam. That is why the tribunal, the authority allowed it 26/4/2003. Directing the managing committee to reinstate the service.
This is the order of the director.
This is not director. Appellate authority. Yes, sir. So thereafter, the institution came into the granted from 1/1/2004. After that, restated. So when proposal was sent to the government and along with my name, my claim was
So,
my claim was rejected.
No, the director passed order to reinstate you.
Reinstate ହେଇଗଲା reinstate ପରେ institution ଟା granted board କୁ ଆସିଲା 1/1/4
reinstate କେବେ ହେଲେ ଟିକେ ଯଦି you have the date please give me.
ସେ date ଟା ନାହିଁ but reinstate that is not disputed so reinstated.
Okay.
ସେ କେତେ ଦିନ ପରେ ହେଇଥିଲା ହେଇଯାଇଛି. So now when the institution became added, from 1/1/2004 proposal was sent in favor of all the staff, including my name.
So it came with effect from
1/1/2004.
GIA fold.
Lockdown, yes.
Yes.
So now my claim was rejected by the.
That is annexure 1.
That is not the annexure 1. That is annexure 5. In that case, I have filed in my affidavit. That is that was challenged before the tribunal. Anyway, sorry. Yes, in the tribunal. The tribunal set aside that order. My rejection order.
Okay.
by the inspector school that you are not entitled to the alternate scale of pay. That was set aside by the tribunal, and tribunal directed in the GI case order also they have given it.
Case is allowed, shall approve the appointment of the applicant and give him granting it at
Alternate scale. That is specific order. But
Yes.
2004, I became trained only on 14 10-14 I became trained.
10-3-2014
I become trained. So my response submission is
এই যে পিরিয়ডটা মজিটা from
বর্তমান মু পাই ନାହିଁ kindly see my lord. এটা হচ্ছে fact more. So both কোন ଦେଇଛନ୍ତି that is also fact. But I have not received my salary from 1/1/2004 to 28/6/2010. I have not paid. That is
28/6/2010
my lord.
This will be on trend.
এটা অল্টারনেট স্কেল পে মত କିଛି ଦେଲେନି ସେମାନେ ଦେଲେ
এটা alternate ପାଇବେ ନା এটা
ଅଲ୍ଟରନେଟ୍ ପାଇବେ କିନ୍ତୁ ଅଲ୍ଟରନେଟ୍ ସେ ଦେଇଛନ୍ତି
ହଁ।
କେବେ ଦେଇଛନ୍ତି 2810 ରୁ 31/3/2013 ପର୍ଯ୍ୟନ୍ତ ଦେଇଛନ୍ତି
Okay. Actually paid.
actually pay 10 ରୁ 13 ପର୍ଯ୍ୟନ୍ତ ଦେଇଛନ୍ତି ଆଉ ବର୍ତ୍ତମାନ ମଧ୍ୟ ତାପରେ
So ଏଇ ଯୋଉ ପାର୍ଟଟା 1/1/2004 ରୁ 26/6/2010 ଟା ଦିଆ ହେଇନି
10 ପର୍ଯ୍ୟନ୍ତ ଦିଆ ହେଇନି ଅଲ୍ଟରନେଟ୍ ଆଉ ଟ୍ରେଣ୍ଡ ସ୍କେଲ ରେ ମଧ୍ୟ ଏଇ 10/3/14 ରୁ ମୋତେ ଟ୍ରେଣ୍ଡ ସ୍କେଲ ବି ଦଉନାହାନ୍ତି
onwards.
ନା ସେ ବୋଧେ he is getting only 5,000 rupees per month till date. This is the plight of a person.
Okay.
This is the difficulty he is facing.
So by which order was it rejected?
My lord, exactly not rejected now.
So you are challenging which order? Annexed 2?
I'm claiming for benefits only. My prayer may kindly receive page 8 of the video. I pray the opposite party 3 be directed to release the block grant of the petitioner in the
No, but for whatever worth, why do you allow this technical consideration to remain? Why don't you challenge this two orders by filing just amending your writ application?
My learned friend filed an application before the tribunal for further clarification. Perhaps
That's single agency to partner. But these order,
These two orders, because they stand on your way. What you are saying that the tribunal's order is sufficient. Yes, I do concede also.
That's the order.
Tribunal
What
says
he said is
it has never been challenged. Tribunal's order has not been challenged.
no, it is challenged and decided.
Confirmed.
It's confirmed.
Yes.
Let us say it is confirmed. So now the question is, what argument they are advancing? I should have challenged annexure 1. I should have challenged annexure 2. Whatever they pay. My response submission, these are not the order to be challenged. Because the order of the tribunal, then there will be a never-ending process to a litigant. How many orders I will challenge, my lord? Every day they will pass. Tomorrow, suppose even if my lord will pass an order, that order of the tribunal is an order of the court. They have to accept it. And while my lord sitting in 226 also, my lord can exercise power under Article 15 on looking into the record and issue a contempt against the officer concerned. Not that every time I will challenge everything. Need not to be challenged. My dispute submission is this.
Yes, your reply. So take it up
fine.
next week then. What up?
But I will also get that order modified.
কোটা
না ମୁଁ ସେଠି ଫାଇଲ କରୁ ମୁଁ ଫାଇଲ
କଣ ସେଟା
ନେଇ ଆସିବ
এটা রাখো তবে ফাইল ভিতরে other arguments in part let's this matter next week. I think Mr. Patnaik is conducting this matter.
yes,
He must be there.
in fact,
yes.
ଆଉ କେତେଟା ପାସ୍ ଓଭର ରହିଲା ଆଉ 6ଟା ପାସ୍ ଓଭର. We'll take up the passover matters and thereafter the weekly list.
before the collector. Collector passed the order that is under challenge.
Original file relating to the proceeding before the collector.
Yes,
The same be kept on record.
I have flagged back the important.
তারপরে হট এন্ড পার্ট প্লিজ দিস ম্যাটার ফর জাজমেন্ট হবে এবার আমার যা লেখা যায় ইয়েস পাসওভার
item number 30.
14
Counter received regendered copy served. It is board re nahi. Today
yes yes
see regendered I served in response to the counter regendered board nahi.
Type machines are still available, Mr. Mahanti?
My lord, say old typist ଗୋଟେ ଅଛି ସେ rely କରୁଛି ତା payment ଟା ଗୋଟେ ଦେଖିବାକୁ।
Then it comes to the petitioner files rejoinder in the court after serving copy on the state. You want it to be done today or?
Tomorrow, let me.
I am prepared.
No, he'll have to go through. No? We'll take it up next week then.
As your lordship.
Place this matter next week.
Monday.
Next Monday.
Again. Item number 16.
Item 16, yes.
It's not hard and earlier previous bench and hearing concluded and written notes to be filed.
It has to be.
Unfortunately, again,
You have to start again. Or if you want, I can send it back to Justice Panigrai. It will be better. He has heard this matter.
He has completely had it.
So it will be better. I'll send it. It will be better. Why should I go through it again? It is submitted that the matter was.
I have submitted the written note.
Earlier heard in full by the coordinate bench presided over by Honorable Dr. Justice S.K. Panigrai.
Both the parties,
And the parties were directed to file written notes of submissions.
Both the parties filed it.
Both the parties have filed notes of submissions today. Since the matter was heard in full by the coordinate bench, it would be better for the said bench to deal with it further. Place this matter
next week
before Honorable Dr. Justice S.K. Panigrai with kind permission of Honorable the Chief Justice. It has to go through the Chief Justice.
Item number 20.
Item 20. None appears on repeated calls. Release this matter tomorrow.
Item number 21.
Same.
Item number 22.
Same.
Item number 23.
Same. Hello. Weekly.
Item number 1.
I request your lordship, it may be taken up tomorrow. I need some further examination.
Pass over for the day.
Obliged.
Pass over के लिए थारी दी थो. कल तो खावा उतरे.
Item number 2.
Item 2 is yours.
Request for short passover. My learned senior is coming, your lordship. He has to argue this matter, your lordship.
All right, pass over.
Obliged.
Item 3.
Item 3.
Item 3.
Yes, sir.
Yes, Mr. Rao.
I think more air.
Mic तक भी adjust करो.
Yes.
Because of the fan.
Facts, to recollect your lordship.
That same matter, though, widow remarrying her children, whether they'll get.
That is settled by your lordship.
I have delivered a judgment.
Yes.
Yeah, you have to reply. Yes, you are for the respondent.
I'm seeking a short passover.
Why?
My learned senior is prepared for this matter. He will be.
Matter of hope. All right, call him.
Yes.
The senior counsel is waiting. Call him. Yes.
Item number 4.
Item 4.
In item number 4, in item 4, I'm opulent. I'm taking up for item because content council is open. So I pray for some part of
2003 matter.
Yes, madam.
This is for limitation, setting aside abatement and substitution. I'll allow it.
Yes, madam.
So what is the delay? Who died? Tell me. It means senior कौन करिवे? कि petition for substitution for whom?
It's just
Who has died?
one. Additional one, madam.
Respondent number 1. When did he die?
Madam, I just out of file right now.
When did he die? Died in the year 2004. So this was filed after 20 years. Ask your senior to come. Pass over.
Item number 5.
Item 5. Again, pass over.
Item number 6.
Chair.
Item number 7.
6 ଅଛି
6 ଅଛନ୍ତି ଆଉ କହୁନାହାନ୍ତି ସେ କଥା
ନାଇଁ
item 6 who died
ଏଇ ଯୋଉ ରେସ୍ପଣ୍ଡ ନମ୍ବର 1 ସେ ମରି ଯାଇଛନ୍ତି ତାଙ୍କର କେହି ଏଆର ନାହାନ୍ତି ପ୍ଲେଣ୍ଟିଫ ଥିଲେ
respondent number 1
plaintiff is the plaintiff now respondent against
there is no delay
ଏଟା admit ହେଇଛି କେସ୍
ଆଜ୍ଞା
କେସ୍ ଟା admit ହେଇଛି dismiss ହେଇଯାଇଥିଲା ତାପରେ
no delay in filing of the petition for substitution
ନାଇଁ ତାଙ୍କର substitution ଫାଇଲ ହେଇନି ତ ସେଟା ଆସିଛି ନୋଟିଂ ପାଇଁ state for substitution not taken ତାଙ୍କର କେହି ଏଆର୍ସ ଆଉ ନାହାନ୍ତି
so we'll record your submission and we'll close say matter ଇଏ କର
ନାଇଁ ଆମେ କହିଲୁ CMPL ରେ କିନ୍ତୁ
okay some order has been passed
CMPL ରେ ରେକର୍ଡ ହେଇଛି ଅର୍ଡର ପାସ୍ ହେଇଛି କିନ୍ତୁ ଟିକେ ତାକୁ ଦେଖିବାକୁ ପଡିବ
opposite party number 1 namely Purna Ansari alias Gonda is dead on inquiry the appellant Purna Ansari has not left behind any legal heirs there exists nobody with a substantive right any other legal heirs on record
କେମିତି ଆମେ ଆସିବୁ appellants ମାନେ class 2 ରେ
so he has to be deleted then deleted at your risk on your submission if you say that the other LRs are on record I can record that if there are no legal heirs then here the proceeding closes
ଆଜ୍ଞା ସେଟା ଗୋଟେ ଖାଲି affidavit ଦେଇଦେବି ପାର୍ଟିର appellants ର ଗୋଟେ appellant
file an affidavit
ହଁ ଗୋଟେ affidavit ନଦେଲେ ମୁଁ ନିଜେ statement ଦେଇ କ୍ଲୋଜ କରିବାଟା
Sri
ଠିକ ହବନି
SK Mishra Lawrence Senior Counsel submits that the respondent number 1 Purna Ansari alias Gonda died without leaving any legal heirs he further wants some time to file
ଗୁରୁବାର ନା ଯଦି ଏଇ ଲିଷ୍ଟ ରେ ଆସିବ ମୁଁ ଦେଇଦେବି
ଚାଲ ଥାଉ ତେରା ପାସ୍ ଓଭର ଥାଉ
ଆଜ୍ଞା
ପାସ୍ ଓଭର
ଫର
କରିଦେବେ ଆଉ
ଆଜ୍ଞା ଏ ଥର୍ସଡେ ପାଇଁ ଟିକେ ଥାଉ କେନ
ଥର୍ସଡେ ଲେଖିଦିଅ
ଦିନେ ଦରକାର ହବ ଟିକେ କରିଦବା
all right item 7
sorry
yes
my
Mr.
lord I am for the respondent no in the previous occasion I undertake to file the vinama for the all LRs they are not coming forward to sign the power so what shall I do so let the notice may be issued to them
notice on which injunction matter
Appeal memo. I have already sought the copy of the appeal memo.
no this has come for orders let us see
There are two other interim applications. Besides that, substitution being allowed, two applications are pending. One is for amendment, other one is for deputing committee.
my order
My order. That is complied. I have complied.
but he says that you are Mr. Pitambar Behra the copy has been served
Yes.
but he says that he doesn't have the wakala
LRs are not coming forward so what shall I do notice to
time
Mr. Behra on whom a copy of the appeal memo was served as directed by this court submits that the LRs of respondent number 1 who have been substituted in his place are not coming forward to execute wakalatnama in his favor. In view of such submission, issue notice to respondent numbers 1A to 1C by registered post. Returnable within 4 weeks. Requisites be filed within 3 working days. 3 working days? 3 working days? Less this matter 4 week पर बोलता हूँ 12th August 4 week ही जाता था ता पराठा कर दो
20 August
less this matter the week commencing 20th August
The
interim order to continue
Item number 8
Item 8, Lordship, we have filed two IAs for substitution of respondent number 2. IA 44 and
IA कितने?
IA 44 of 24.
44 of 24.
Another one is IA 45 of 24. 2 second appeals are there.
Yeah, this 44 is, this is one appeal, second appeal. Let us deal with that first. When did he die?
He died on
20/12/2023.
my lord.
So no delay.
No delay, my lord.
All right. This is an application for substitution of respondent number 2, Kamini Kanta Purohit, who died on 20/12/2023, leaving behind his widow and son, the particulars of whom are described in the, where have you described it? In the schedule to the IA. So, it is submitted that the right to sue survives against the LRs of the deceased respondent. Further, the petition for substitution is in time. In such view of the matter, the prayer for substitution is allowed. The persons as described under schedule to the IA be added as respondent numbers 2A and 2B. You'll appear for them or notice has to?
Notices to, we do not have instructions, although we are appearing for all the respondents before. And when respondent 1 also passed away, we took instructions and we appeared for their legal heirs. If your lordship permits, I'll take, there is no requirement for issuance of notice, I'll take
right.
instruction.
Your good name?
S. Das. Shraddha Das.
Miss Shraddha Das, appearing for the other respondents, seeks some time to obtain instructions as to if she can appear on behalf of the newly added respondents. Place this matter in the week commencing 29th July. This court will apprised accordingly.
Next item.
Next is same.
My lord. IA 45 of 20.
Next step is same for that. देखिए IA number to change करो. Item 9.
Sir, plan number 1 died. Her legal heirs are already on record. IN number 796/23 to delete her name.
Who died?
Appellant number 1. Bajabe.
Other LRs are on record.
Other appellants are or legal heirs.
IA 796 of 2023. The appellant number 1, Baja Beva, died on 9/5/2023. It is stated that his LRs are already on record as appellant number 2 to 4 and respondent numbers 3 and 4.
Yes.
As such, no substitution is necessary. The IA is disposed of accordingly. Yes. Then
another IA 810/23 in respect of respondent 1, Boiragi Vera, who died on 14/6/23. Substitution in time. Application.
Filed on within time.
Within time.
This is IA 810/2020. This is an application for substitution of respondent number 1, Boiragi Charan Behra, who died on 14/6/2023, leaving behind his LRs as described in the schedule to the IA. It is seen that the petition for substitution has been filed in time. It is submitted that the right to sue survives against the LRs of the deceased respondent. In such view of the matter, the prayer for substitution is allowed. The LRs of the deceased respondent, as described in the schedule, be added as respondent numbers 1 small a to 1 small d. You will appear for them.
I am 1 and 2.
One to Mariole.
One more.
Tanga LR ko may apa appear karibe na notice jibo.
Notice.
Notice jibo. Issue notice to the newly added. Apna address ଦେଇଛନ୍ତି? newly added respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. List this matter in the week commencing
20th August.
20th August.
Consolidated cost title I will file.
Consolidated cost title is also consolidated cost title be filed in the meantime.
Another noting notice was issued to respondent 6.
Respondent number 6.
I have to
Kebe
take
jayechila?
steps. Notice was noting in or return.
Author legal?
Yes, I registered post.
Issue notice on respondent number 6 by registered post same kar dala. Requisites within 3 days, Mr. Mahapatra.
WhatsApp item number 10, I am for the appellants. We have filed a miscase for extension of stay, my lord.
For order or stay. There are 2 interlocutory applications. 593 of 17, 345 of 18.
Lord, 345 of 18, my lord, that is for stay of execution, my lord.
Any order has been passed in that?
Yes. Stay was granted, but during the, my lord, COVID period, that stay was vacated. And thereafter, my lord, we came to know in 2023, thereafter we filed our IA, my lord, for extension of stay.
593?
Yes, my lord.
For continuance of the stay?
813, my lord.
For continuance of the stay order?
Yes, my lord, 813.
The LCR has been called for. Is it otherwise ready, Mr. Panda?
Otherwise ready.
Yes?
Otherwise ready.
Otherwise ready, hearing kar daba aap.
My lord, LCR ta ठीक है.
LCR asini?
Noting re nahi.
देखिले बेस करे अच्छी yes
You direct the court below to send the soft copy. LCR अच्छी
अच्छी ना आ गया
LCR 2 brief लिखा है जी देख ले ना थोड़ा बनाई गई थी LCR digitized. Yes. Is there any Xerox copy of the LCR? All right. The digitized copy of the LCR be made available. No, it is submitted that the matter is otherwise ready for final disposal. The LCR, it appears that the LCR has been digitized. The digitized copy of the LCR be tagged to the case record. List this matter in the week commencing 22nd July for hearing.
Okay. My lord, interim order to continue.
Yeah?
Interim order to continue.
Interim order kar daba. In this case, 593 of 2017.
My lord, 345 of
345 of 2008. Further proceedings in execution case number so. Arising out of so. Year shall remain state till the next date.
Obviously.
11 your lordship substitution was there within time. This matter is to be heard once the substitution is regularized. I am praying your lordship may fix a date of hearing and
substitution you have to substitute no
Darkhasta dechi your lordship. The last occasion the IA was called for.
IA 225/18.
7/29 of 2024. What I have gathered from my associate that it was called for and may not be scanned, my lord, but in the physical copy it is, I guess, I believe it is there.
No, he died on 11/4/2024 and you said that he will be filing within 3 days. So you filed within 3 days.
No, 3 days within the limit.
Again.
3 days recording.
IA is not there.
My lord, IA is there.
No, but IA it has not come. 779. Yes,
Again.
779. Who has died? Since it is within time, we'll allow it upon. The IA 779 of 2024.
Let us say. Achha.
No.
779 or 729?
779 likho.
My lord, ठीक है.
779. This is an application for substitution of the sole appellant who died on 11/4/2024. It is submitted that the right to sue survives on his legal heirs. Further, the application for substitution is in time. In such view of the matter, this court is inclined to allow the prayer for substitution. Court tango detail the court ichindi.
Take time interveners have cost title because the sole appellant has died, so they are the applicants who your lordship. I'll file the consultative cost title by.
That I will say, that order will be there, formal order will be there, but I'll list the LRs of the deceased appellant. The details of whom are described in the cost title of the IA be added as appellant numbers 1A to 1C. Consolidated cost title be filed within a week. Stop. It is submitted that the appeal is otherwise ready for hearing. Has it been admitted?
My lords, which is substantial question of law. It has been
And LCR has been called for.
That LCR, my lord, I am not able to locate it from the list, but your lordship will kindly see order dated 30/10/2021. LCR টা অফিস কল ফর করতে যদি এটি অর্ডারে নাই
না এই নথিলে ବି অফিস কল ফর করে দিଅନ୍ତି ନା
আগে
let us see whether the like in the previous matter there was no order but the officer called for and it was digitized.
Once admitted, normally LCR is called for by the office. আসেনি LCR টা কল ফর করে ওটা ডেট তো ডিসাই LCR আসিবে
হ্যাঁ for hearing with photocopy of LCR দেখলো
LCR নোটিং ডাউন নোটিং
আচ্ছা বাবা ফটোস কেতেটা আছে
একদম 11 নে কোঠি নোটিং নাই LCR আছে
নাই ଆମର ଏଥିରେ ଅଛି photocopy ବୋଲି ଏଥିରେ office note ଅଛି
my
if that is available we'll take it up.
My lord, your lordship, I will only pray breathing time for fixing a date of hearing.
Yes, we will give you breathing time, we will give you oxygen, we will give you ventilator, whatever you want. ଅଛି ତ ନାଇଁ ଏ ବଳରାମ ଦେଖ 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 LCR ଟା ଅଛି କି ଦେଖ ତଳେ ବନ୍ଧା ହେଇଥିବ ଗୋଟେ ଜେରକ୍ସ କପିରେ ଅଛି ତ ଖୋଲ
Scanning ହେଇନି
ହେଇଥିବ is new so
that is once they are trained my lord ଆମକୁ ସ୍କାନିଂ ହେଇକି କାଳେ your lordship's reference ଯାଇଥିଲା
ନାଇଁ ସ୍କାନିଂ ଟା ନହେଲେ ଭଲ
ଆଜ୍ଞା
the way they are scanning and the way they are depicting the booty which is known as the metadata
that will be more difficult to
unless one is acquainted with the record one will not be able to find out right the photocopy or digitized copy of the LCR be tagged to the case record. Let this matter in the week commencing 29 July. केतिक था तो पास ओवर को चलो the rest of the orders matters I will take up tomorrow because there are some part of matters I will take up.
He is there. And understand, I am told that my understand the appellant has completed the appeal.
Which one?
Item number 3.
We are waiting for you. You have to conclude.
So grateful, but I'll just do it. Can I?
Only small question: whether
Yes,
the
it
children of a widow remarrying have any?
Exactly.
I having decided very recently in a judgment, I don't know what.
But what your lordship has decided, in fact, I do not know.
You have to know.
I'll know it. Definitely, I know it.
जब कोर्ट को जो सही कोर्ट में कौन डिसीजन है मनोटा इसे अपने जानी मानी you are too senior for that Mr. Author.
But I'll
to try to understand the mind of the court.
General study.
Whether the widow remarrying and the children begotten out of the second marriage, whether they can have the right
They need the property of the original first cousin.
Yes, yes, that is the only question. And that is the exact same question I have decided.
I don't know what you are. In fact, I'll have to go through that. But I'll cite one Supreme Court judgment and provision of law. That's all.
Yes, yes.
There is no dispute about this proposition. Lakshman Barik is the original person. He had wife, kindly see this genealogy. Jambuvati is his wife. Now, Prahlad is son of Lakshman. Kiyavati is daughter of Lakshman. Sumitra is the wife of Prahlad. Correct, Miller? After death of Prahlad, Sumitra married to someone else.
Yes.
And through the second husband, this plaintiff she has been begotten.
What is the name of the plaintiff?
Annapurna Pradhan.
Is it Lekhina Devan?
It is Lekhina because the other husband are beloved.
Annapurna au kiye? Na jane?
Annapurna, jane. Plaintiff is Annapurna, daughter of Sumitra through second husband. Jehetu anchor lineage ra chasuni wo sek mein takti. Now she files a suit to declare that Trinath is not adopted son of Sumitra and the entire property, she is entitled to succeed to the entire property left by Prahlad. Admittedly, properties are of Prahlad. Now, after death of Prahlad, obviously it will go to the wife. Since wife remarried, now question is the daughter born through the second husband to Sumitra, whether he will succeed to the properties left by Prahlad or not. That is short point. Now, trial court dismissed this suit. I am sorry, trial court
decreed the suit.
Decreed the suit. Yes, trial court decreed the suit. We went in appeal, appellate court.
I think better, we will take it up tomorrow. You go through my judgment. It may not, you may argue against it, but you have to go through that judgment.
Now, if your lordship has held that the state daughter will be entitled to Arva, that probably your lordship, in my humble opinion, may reconsider. Because of
that is in another case. That is in another case.
Lordship may kind it. 2002 Supreme Court is directly section.
Let us see.
Section 50.
I may have missed it. Let us see.
Yes. Right.
Section 24. You are referring to. Yes, Mr. Ratha, you are referring to section 24.
No, I am referring to section 15.
15 is all right.
See, kindly see section 15 only. 15 2B. Lordship has got Hindu Section Act. Sir, the property of a female Hindu dying intestines are given upon according to the rules set down in section 16, firstly upon son's daughters. Lordship may say, since under section 14, after death of Prahlad, the property becomes absolute property of Sumitra. Then obviously it will go to the sons and daughters. On her death, it will go to the sons and daughters. There is a proviso subsection 2B. Kindly see. Any property inherited by a female Hindu from her husband or from her father-in-law shall devolve in absence of any son or daughter of the deceased, including children of predeceased son or daughter, not upon other heirs referred to in subsection 1 in the order specified therein, but upon heirs of her husband. Am I clear, sir? So, the widow inheriting property from husband, on her death, the property will not be devolved upon the heirs 15(1) to E, in which this plaintiff coming, daughter of Sumitra, but it will go back to the husband's heir.
Who will be the class 2 heirs?
Husband, yes, class 2 heirs. Now, that is what is held in 2002 Supreme Court. So, what the appellate court?
So, you see, there may be a distinction in facts also.
Yeah, maybe. I'm not sure about that fact. I'll have to go through the judgment. If I get a copy of that fact from the...
You give the number. Yes. You can download it and get it. We'll take it up tomorrow.
Yes, ma'am.
We'll finish it tomorrow.
Yes, this is the point. I have almost finished it.
No. The only point, Miller, he is now appearing for the adopted son. Both the courts have that he is not the adopted son, that is not challenged.
That is what I'm saying. You have to consider the facts. That is exactly what I'm saying.
Yes, no law extent, you know, to stand here.
Not adopted son, I am for this nephew also.
Kindly.
It's not like that. Facts cannot be two state like this.
No. I am
it's not like that.
Sorry, I am not last person to this state.
Sir, please.
Facts. Very sorry, I am.
It's a question of law. I am also making, sir. I have not finished. It's a question of law.
Permits, I will make submission, he has no losses standing to stand. Like this. Sumitra is the sole proprietor of the property. There is no dispute about facts. At that time, the defendant number 1 is not the branch of this, nothing to do with. He said he is the adopted son. On the basis of that, he got the land mutated in his name. Facts are not disputed, your lordship kindly note. If anything is wrong or not correct, let him make submission. Thereafter, I filed appeal. Plaintiff filed appeal stating that he is not adopted son. And that appeal was rejected. My appeal was rejected. Then I filed the suit. For a declaration, I am the sole successor of the Sumitra. Second, he is not the adopted son. Suit decreed. Holding that he is not adopted son. And the appeal was filed. In the appeal also that finding is confirmed. So his adopted son story gone. His only claim to claim this property on the basis of adopted son. And appellate court further held confirmed the finding of the trial court, stating she is the only daughter who will succeed the property. But abruptly she has said, as if she is not the child of the second husband, through second husband, it will go to the property of Prahalad. Because only that extent. He has given a finding that this present plaintiff is the sole successor heir of the Sumitra, but he has said the property not in respect of the suit property. That is, when the Sumitra has no child through second husband, then what we said the appellate court is correct. But here there is no dispute that the plaintiff is the daughter of Sumitra through second husband. Now the plaintiff, now the present appellant, who is the adopted son, claiming adopted son, got the property in his name. Now that has gone, in view of the finding, and that finding is not challenged before the Hon'Ble court. So what it is locus standi to stand and make a submission, That's why I have said, that he has no locus standi. And he is not claiming, there is no dispute. He has not disputed, entire pleading I will place. That Sumitra is not inherited the property of Prahalad. As a Prahalad, Sumitra inherited property, he has claimed that I am the adopted son, that property will come to me. And got mutated. That story has gone.
All right. Okay. Yes. My lords, my learned friend is shockingly incorrect on fact. Shockingly incorrect on fact. Yes, I say shockingly incorrect on fact. Let us see the plaintiff, whom you have pleaded a party defendant in the trial court. Kindly see, my lord, and see from the genealogy. Shockingly incorrect on facts. Kindly see. You are the plaintiff. You have implicated Trinath as defendant number 1. You have implicated Pradyumna Shah. He is the second line of successors, those class 2 heirs. Brother son of Prahalad. Kindly see, that's not disputed. That's not disputed. You yourself admit in the plain. Now today, Trinath, see, he is only one side. Trinath is claiming as adopted son. That's fine. But the suit is dismissed, suit is decreed, having held that Trinath is not adopted son. Adoption is held to be negative. Correct? Fine. Now, both Trinath and Pradyumna, the second reversional, brother son, both of them filed appeal. He is not correct in saying that Trinath filed appeal. So these are the issues where my learned friend is incorrect on facts. No, 1 second, 1 second. Let me tell you. One second, please don't disturb like this. So Pradyumna is very much one of the appellants. It's a question of entitlement as per law. If this, in terms of section 15(2)(b), this Annapurna is what the appellate court has said. Kindly see, appellate court has said that so far as the adoption part, appellate court has said that he is not the adopted son. Correct, Mela? Kindly see that part of the order. But appellate court on the question of Annapuna's right has completely gone wrong. If property doesn't come to Annapurna, then it will automatically come to Pradyumna. And I am one of the appellates before the appellate court. And I am before my lords also. So he cannot say that I have no locus standi. Am I clear, my lord? So this part he is trying to obliviate. He is trying to obey.
Hold it. We'll continue tomorrow.
Right, sir. Right.
Just go through.
Yes.
Whatever work you go through, then
I'll do that.
we'll
I'll do
complete
that.
it.
Yes,
Pass over.
Grateful.
ସେ ଭିତରେ ରଖିବ ଫାଇଲ ଭିତରେ ବାନ୍ଧିକି ରଖିବ ଏଇ ଯୋଉ ଫାଇଲ ଆଉ ଦିଟା ଥିଲା ପାଠ ମାଠ ଡାକ item number 1 is also a part of matter.
The passwords were
One I requested your lordship to.
Oh, you are ask for a password.
Your lordship, password the day.
All right. Item 2.
Lucas was doing in front.
Who's for the other side?
Your lordship, no one appeared.
No, there's a name. Mr. S.B. Mahanto, G.K. Nando.
Somebody is there.
Someone was there. Anyway, 2004 matter, I'll not keep it pending. Please.
She was arguing it. She should continue.
Yeah?
She was arguing it.
Let her do that. You please take rest. Let her argue.
Your lordship, I would like to start from the facts to refer.
कौन सारी briefly to कहूँ तो मन पड़ जाए.
Briefly, so it is a confirming judgment. It's a suit for partition for claiming 1/3 share in the suit property. I had placed the genealogy earlier.
Genealogy टा देख लो कागज टा बोले थे वो. Yes, begin.
Yes. Your lordship, Gobinda Mahanta is the common ancestor from whom there were 3 branches, 3 sons. One was Chandramohan Mahanta, Shatrughna Mahanta, and Harihar Mahanta. The plaintiffs belong to the branch of Shatrughna Mahanta, and the defendants belong to defendant 1 to 4, and defendant 6 belong to the branch of Chandramohan Mahanta, and defendant 5 is Harihar Mahanta, who is the 3rd branch. The plaintiffs' case is that the plaintiffs and defendants had no other joint land except the suit land. In 1951, the suit land was purchased by the sale deed by all the 3 brothers. They possessed and cultivated the suit land, jointly appropriating their 1/3 share. In 1965, the same arrangement continued in respect of their legal heirs after the death of Shatrughna Mahanta.
He holds that there is a prior partition.
Yes, the defendants have claimed that there was a prior partition in 1959.
That has been accepted by the court.
No, your lordship.
The suit was decreed.
The suit was dismissed. Yes, your lordship.
Decreed.
Decreed
And reversed in appeal.
No, allowed in appeal. This is a confirming judgment. Reversed, allowed in appeal. No, sir.
You are the plaintiff, or you are the defendant.
I am the defendant.
Defendant number?
Defendant number 5.
Harihar.
Harihar.
Acha.
Appeal was dismissed.
Let us go to the judgment of the trial court. Judgment of the trial court. So there was an issue framed regarding prior partition.
Yes, your lordship. Issue number 3.
1959. Issue number 3 actually meant.
Okay.
The property is joint unless contrary is proved. What was the holding? What is the finding? On the basis of an unregistered partition deed, isn't it?
Yes, your lordship.
The entire document is observed. The suit land was not partitioned by meets and bounds, even though there was severance of status.
Severance of status.
Okay. Then, how does defendant number 5 come into the picture?
Defendant number 5 is the 3rd branch. The defendant number 5 and defendant number 1 to 6 had the suit land share in the prior partition. while the ancestral properties, which the defendant number 5 claims that we had other ancestral properties and suit land is not the only joint property of the.
So it becomes a case of partial partition also.
Yes, Your Lordship.
So, parties are directed to referral. Plaintiffs are entitled to 1/3 share of the suit land. Parties are directed to referral. So, what happened in the appeal?
Appeal, Your Lordship, has confirmed the findings of the trial court, but Your Lordship, additional evidences were adduced under Order 41, Rule 27
Additional evidence of what?
of sale deeds from the ancestral property showing that there was a prior partition.
That each co-sharer is dealing with his share of the property independently.
The plaintiffs already had the share of the ancestral property.
They're dealing with the property independently.
They have received benefit.
What is wrong in it? What is wrong in the finding? It's a confirming finding.
Your Lordship, if we look at the Exhibit B, it is admissible. It is admissible under evidence as a family arrangement where there has been allotment of shares. It may not be admissible under Section 49 as it is an unregistered deed, but Your Lordship, it is an indication that there was a severance of status and the parties have acted upon it.
ये जो कौन है तो ना बिक्री को बढ़ाना कौन है तो कुछ नहीं ये किसी देखा जाओ नहीं इसलिए बाबा किसी देखा Exhibit A1 B1 there is Exhibit B you are referring to
Yes, sir.
LCR hard copy अच्छी देख लो hard copy अच्छी हाँ देख जाने आप पूछते Do you have any legible copy with you?
Your Lordship can do it.
Either. Bhagavantana Patra. This was unregistered, 23/3/1959.
Yes, Your Lordship.
Oh, well, the court disbelieved this document.
Your Lordship, but the court should have at least admitted the evidence on the ground that this is a form of family arrangement which has been acted upon by the parties. They've received the parties and this does not require a registration according to the law. Your Lordship, may I place before you the judgment of 1976 3 SCC 190?
What does it say?
Your Lordship, it says that it is well settled that registration would be necessary only if the terms of the family arrangement are reduced into writing. Here also a distinction should be made between a document containing the terms and recitals of a family arrangement made under the document and a mere memorandum prepared after the family arrangement had already been made either for the purpose of the record or for information of the court for making necessary mutation. In such a case, the memorandum itself does not create or extinguish any rights in immovable properties and therefore does not fall within the mischief of Section 17(2) of the Registration Act and is therefore not compulsorily registrable.
Let us see that part of the judgment
Yes.
where the court has dealt with this aspect. What the judgment? What the appellate court judgment? Come to the appellate court judgment. Yes. So your case seems to be revolving around that Exhibit B.
Yes, sir. Regarding the Exhibit B, Your Lordship, the court has made observation that the partition deed is page number 15.
Page number 15.
Yes, Your Lordship.
Yes.
Exhibit B is prepared allotting Keunjhar and Moyurbhanj property to Shatrugna only and allotting the suit properties to Chandramohan and Harihar
and the oral evidence to that effect are not believable to prove previous partition. Rather, the same belies the plea of the appellant. The exact date of the partition has not been mentioned in the written statement filed by the defendant number 5 and 6, which creates suspicion about the existence of Exhibit B. Exhibit B cannot be taken into consideration with regard to previous partition because that being a partition deed is compulsorily registrable and therefore it is an invalid document, and the same cannot establish the prior partition of suit properties. That apart, the schedule of properties which were partitioned are not mentioned therein. Similarly, it is not mentioned which fell to whose share. Your Lordship, that has been clearly mentioned in the Exhibit B, which property fell to which share has been mentioned in the document. And when the defendant 5 is claiming the partition, it is claiming the partition combining both the properties, that is the ancestral property along with the joint property, the suit property.
ସେଟା କେତେ ସେ ଯୋଉଟା compulsory registrable ନୁହେଁ ବୋଲି ଯୋଉ କହିଲେ
Compulsorily registrable, Your Lordship. Para number 10.
ନା ନା ସେଟା କେତେ ମାନେ ଇଏ citation ଟା କଣ
Citation tell us 1976 3 SCC 119.
Yes. So this document is an exhibit mark ହେଇଛି admitted ହେଲେ କଣ evidence
It was not considered.
It was not considered. Why is the question of Order 41 Rule 27 being raised by you? Which document do you want to incorporate?
Sale deeds.
Okay, sale deeds.
Sale deeds.
No, tell me why were these sale deeds not filed before the trial court?
Your Lordship, they were not available at the time.
What is the meaning of not available? How could they become available then?
It was not in the possession of the defendants at the time of the trial, and it was.
Was there any pleading to that effect in your complaint, in your written statement?
Your Lordship, the written statement said that it will produce.
देखिए written statement देखिए. Let us see your written statement. So this is the point.
Can I just add a few?
Yes, please. Yes, please, sir.
Whatever she has said is correct. Well, there are 3 items of property: Kemusher and Mayurbhanj, ancestral property. Cuttack property was purchased in 1951 by the 3 brothers. So there was an arrangement between them in 1959, March, sometimes in March, it is there.
That Exhibit B.
Exhibit B in one line is there. Cuttack property was given to Harihar and the plaintiff. And the Kemusher and Mayurbhanj property was given to the other branch. The plaintiff's father, who was alive at the time, he said, no, I am not keeping well in Cuttack. I want to take the Mayurbhanj and Kemusher property. The other brother who has been allotted that property should be given the Cuttack property along with you. So that was the understanding for which Exhibit B has been written. So Exhibit acknowledges about the previous partition, only a rearrangement with regard to Cuttack property was made. That is why the document is admissible in law, and that has also been marked as Exhibit.
Exhibit B.
Exhibit B. The reciter speaks about the properties. Court says you have not given the details of the property. The entire property has been given to plaintiff, Kemusher and Mayurbhanj. These additional evidence documents show in 4 sale deeds, plaintiff himself and his father sold those properties to different persons. So during his lifetime, he has exhausted all these share. Kemusher and Mayurbhanj sold it to different persons. Only left is Cuttack. Now he says Cuttack property should be divided into 3 parts. After enjoying those properties, now he wants a share in this.
No, I would like to know whether this plea was taken in the written statement by defendant number 5.
It has been acted upon. That is what it has been mentioned.
Let us see.
In the written statement. So court says you are not given the date of partition. So it is there.
The lordships,
Specific
12.
59.
That they were exclusively or independently dealing with those properties.
The lordship, 12, para 12 maybe.
Of the written statement.
Yes, your lordship.
Go on.
There was an amicable partition.
Yes, pardon.
That the true facts of the case are as follows. There was an amicable partition by meets and bounds in about year 1959 between Shatrugna Mahanta, Chandra Mohan Mahanta and defendant number 5 in presence of late Chandra Mohan Mahanta, late Kushal Chandra Acharya, late Jadunath Mahanta, Shri Niranjan Mahanta, and suit properties were allotted to defendant number 5 and late Chandra Mohan Mahanta in the said partition. And since then, late Shatrugna Mahanta and present plaintiffs were never in possession of any portion of the suit properties. As such, the question of the plaintiffs appropriating their alleged 1/3 shares of suit properties does not arise. The defendant number 5 is in peaceful possession of 5.11 decimal of Schedule A property, and the defendant numbers 1 to 4 are in possession of the other 5.11 decimal of the suit property to the complete exclusion of the plaintiffs and late Shatrugna Mahanta. The alleged purchases in 1951 have no relevance since all the properties of family, including the purchased properties, were pooled together and were partitioned in the amicable family partition. The said properties have become the properties of defendant number 5 and late Chandramohan after partition.
You have a copy of your Order 41 Rule 27 application.
The legal position that dissent says that 76 Supreme Court, it says if it creates a partition by a document, compulsory registered. If it acknowledges previous partition,
not registered,
not required. And another thing is, even if it is required, traditionally it has not been registered, parties are stopped to challenge if they have acted upon. So that is the law. They have referred to number of judgments, and that judgment has been followed, 70 Supreme Court. In subsequent judgments, even 2022 judgment also, Supreme Court says that. Yes.
I want you to find out the 4127 application. It is necessary because the court has to be satisfied.
In para 7 or 8, discuss about the documents which is supposed to be added as additional evidence. Said you have not filed the earliest possible time, therefore I will not accept. Sir, Order 41 Rule 27, the last clause says,
for any other sufficient cause.
If the sufficient cause enables the court to
pronounce judgment.
Right. So,
no, that is there. That is there. Adjudication. But this court would like to be satisfied that you had acted diligently.
Right.
So that is why I am asking.
Exactly.
Go through the LCR. Find out whether it's a LCR korcheti bhavan. Becoming very difficult to deal with these matters.
That's the e-filing creating real problems.
No, this digitization thing, those who are doing the work, the scanning work, they have no idea about the and index petition so Order 41 Rule 27 petition I would like to see. What have you mentioned? You must have definitely mentioned why you could not file it earlier. What reason you have given?
Court has observed that.
No, आपन कौन फाइल कुछ देखा तो
नहीं application
original document आपको समझ देखेंगे primary source का देखेंगे
ठीक हो ना देखो sir actually my submission is that a court file is whatever a Jajpur appeal.
Now the question is, supposing the court accepts it, that these documents ought to have been taken into an additional evidence. Now what would be the final order?
So if the other side has executed this, so it is not a document which takes the other side by surprise.
No, it is against their pecuniary interest.
Right. But the question arises, if the plaintiff has himself executed the document, can he say, no, this is not the original document, this is not the document I have executed? I can understand a new document which is not, he is not a party, he he should be given opportunity to revert it. But here I don't think any chance of reversal is necessary.
No, what will happen supposing this court accepts your plea? So what are, it has to be remanded probably?
To appellate.
Appellate stage. That is what I'm saying. At this stage, the 2004 matter, we are 20 years. Yeah, this appeal is 20 years old. That is the difficulty. And this court cannot, I mean, can always, but in a second appeal to enter into that factual aspect to examine the implication of that sale deed, that I think the first appellate court is best suited to do. Best being the last court of facts.
That's right.
But you find out that petition. I'm closing it. I'm giving you 1 week time to file a note of submission. In the meantime, you can. What were the two? I had just gone through the
substantial question of law.
And
one of the ground is order 41 to 27.
Yes, is that
there is non-consideration of all these materials.
Whether the rejection of the petition. Because if the first question of law is answered in your favor, then the natural, the consequential order will be remand. So the courts will have misconstrued the evidence available on record to accept the plea of jointness when the defendants have established severance of status and prior partition. Now this will depend on the first. Whether there was a prior partition or not, that there has to be a clear-cut finding.
So with due respect, not assuming the order 41 that subsequent, I'm sorry, the order 41 to 27 is not to be considered. Still, sir, if he is a party to the document, which shows there has been a partition by arrangement, and the party never disputes that, is it not estoppel? That is what the Supreme Court says.
But it has to be, for that, it has to be admitted into evidence. It has to be brought on record. Isn't it?
It has been admitted. Exhibit B has been admitted.
Exhibit B has been admitted. But what about the documents, the sale deeds, which actually clinch the issue according to you? That they were dealing with the property on their own.
Even on evidence, he has accepted that he has sold. In evidence,
particular sale deed को तो refer करिकी तो confront करा जाई नथिबो. Correct. Say sale deed टा थिले आपण what you would have done is substance during trial you would have confronted it. You have sold this property at the RSD number so and so. All right, sir, I'm closing it. You find out that petition. And you enclose it with your note.
Yes.
Hearing concluded. Note of submissions and memo citations, if any, be filed within a week. ये क्या कर रखो? हम फाइल रखो. चला. तीन नंबर टा? हैं? तीन नंबर टा. ठीक है. तापरे.
Number 4.
वो तापरे सरला. पासवर्ड छाड़ो. चलो ऑर्डर 41 को चलो.
Item 4 milots.
Order 41.
Item 4 milots. I may be pardon milots. Item 4.
Item 4 has been passed over. Yes. What do you want?
I have requested my colleague. I am suffering from fever. He called me that your lordship was requiring me. Can it be a passover and it can be can it be heard on Friday, milots? Particularly on Friday.
Friday. Item 4 tapu mark kar do Friday. Yes.
Item 5 minute.
Mobilized milots.
I have filed one substitution petition. The substitution petition notice has been issued with the LRs of respondent number 1.
Why was notice issued?
Whether notice issue notice issued on 23/2006.
Why was notice?
No, sorry, madam. The LRs of already appeared on 14/11/2014, madam.
Yes.
Then thereafter one LR is not appear. Then against him notice has been sufficient on 2/8/2019, madam. So miscase should be disposed of.
So notice was issued after substitution of the deceased respondent.
Yes, ma'am.
All of them have appeared.
No. 4 appear, 1 not appear. Against him notice has been sufficient, madam.
Notice is sufficient.
Yes, ma'am.
So then what next?
I have to.
Why has it come for orders?
Orders for
fixing early date of hearing.
Yes, ma'am. For order for resubstitution of digit.
Anybody appearing?
Yes, my lord.
I think this matter I cannot hear. Mr. Gurudatta Karo is probably appearing for the other side. I am concerned. list this matter before any other bench with permission of Honorable the Chief Justice as I am concerned. No, order 41. No. Anybody in orders matters?
Item 19.
Orders. What is John? ମୁଁ ତ କହିଥିଲି ନେବେନି ବୋଲି ତ ଯିଏ ଥିବେ ମୁଁ ନେଇଯାଉଛି. Order 19. Yes.
In this case, the arrest not admitted.
Limitation.
For question of limitation.
Notice will go.
My lord, in this case, one injunction petition also filed.
Notice ଯିବ ଦୁଇଟାରେ delay control ହେଲେ ସିନା injunction ହବ.
ଖାଲି notice ଟା ଯାଉ in question of injunction. My lord, the nature of the case, my lord, mother sold the case land to daughter-in-law.
Anyway, let
after genealogy,
let notice go.
My lord.
ଆଉ ତ କଣ notice ଯିବ. IA ରେ 788 of 2024 issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days.
My lord. Out the injection ଅଛି.
This is matter on in the week commencing 20th August.
My lord. ଆଉ both ଯେ question of injection ଟା ଲେଖା ହବା ଦରକାର injection ଜଣା ପଡୁନି notice.
ଦିଟା ଅଲଗା ଅଲଗା କରିକି notice IA ନେଇକି notice କଲେ ହବନି.
ଗୋଟା limitation ଗୋଟା injection ହବ. ଏଟା
Yes.
That item number 13 mile.
Yes.
13 mile.
No, ଆଉ ପଛକୁ ନା.
Requisite file
within 3 working days. Separate requisites ଦିଟା ପାଇଁ file କରିବେ.
My lord.
13 ରେ କେବଳ ମୁଁ IA file କରିଛି substitution in the year 2023. That has not been reflected in the cause list, my lord. The
Item 13.
My lord, 13 there. The respondent.
I'll list this matter next week along with application for substitution filed, said to have been filed by the appellant. Yes. Hearing order 41 rule 11.
21.
2003 matter are not admitted.
It's not. Your lordship will see challenging
I admit Korea.
the suit is barred under the UL Act. Suit ta file challenging the action of the settlement authorities and the Tahsildar in computing the nature of land. ଆମେ କହୁଛୁ ଯେ ଏଟା schedule category 4 land ସେ ତାକୁ category 2 କରିକିରି vest କରିଦେଲେ 7 acres of land and it has been distributed. ତାପରେ appeal
Confirming. We will have to pass an order to. Acha. This is an appeal against the appeal by the plaintiff. By the plaintiff against a confirming judgment.
Okay.
Stop. The judgment passed on 8/8/2002, followed by decree by Leonard, Additional District Judge, FT
FTC
Balangir, in title appeal number 62/1/8 of 1998-2002 is under challenge, whereby the judgment dated 30/3/1993, followed by decree passed by the learned additional Munsif Balangir in
PS
title suit number 7 of 1985 was dismissed. It was confirmed, sorry. The suit was filed by the plaintiff for declaration that A schedule land is class 4 land and does not come under the category of class 2 land, along with perpetual injunction against the defendants and recovery of possession. Stop. The plaintiff claims to be the rightful owner of the scheduled A and B lands, as also to be in possession. the Tahsildar and Revenue Officer Bolangir initiated a suo motu sealing proceeding against the plaintiff under Chapter 4 IV of the OLR Act 1960 in the year 1975, being case number 2281 na sir kehte 2261 2281 of 1974, changing the kism of land and wrongly classifying it as class 2 land under section 2 bracket 5 bracket E of the Act. According to the plaintiff, said order was passed without following the procedure laid down under Rule 4 bracket A of the OLR Act. In the process, land measuring acre 5.21 decimals as described in the schedule to the plaint were declared as sealing surplus land and vested on the state. The plaintiff was served with a notice to deliver possession of the Schedule B land. Stop. Hence the suit. The state defendants, though filed the written statements, were set ex parte. It was admitted that the holding number 162 was recorded in the name of the plaintiff, but they are no longer the owners in possession of the same, as the entire land has vested to the state in view of the decision rendered in the OLR case. Further, the kism of the land was changed on due inquiry, including spot inquiry, and the nature thereof was accordingly determined. Stop. Yeah, to. I will just
And no illegality has been committed.
In short, it was concluded that no illegality had been committed. Stop. Basing on the rival pleadings, issue frame is again. Rival pleadings, the trial court framed
5 issues.
5 issues as described under paragraph 4 and quoted herein below. So, quote paragraph 4 of the judgment. After considering the evidence and the contentions raised, the trial court found that that proper procedure had been followed by the Tahsildar in classifying the suit land as class 2 land. It was further held that the Tahsildar having followed due procedure, and there being no irregularity or illegality in the order passed, no order of injunction can be passed against the state. Stop. এটা ভুলে গেলা বললা যে এটা মানে
proper classification যে করেছেন ইস্যু নাম্বার 5
ইস্যু নম্বর 5 এটা 5 এর আছে না সেটা আমি ভুল নম্বর পেজ নম্বরটা ভুল করে দিলি The suit was thus dismissed. Stop. The plaintiff carried the matter in appeal to the district court. Stop. Then at first appellate court, after going through the evidence and on examining the procedure adopted by the Tahsildar, found no infirmity, much less any illegality therein, so as to be persuaded to interfere. Stop. As such, the first appeal was also dismissed. Stop. Being further aggrieved, the plaintiff has approached this second appeal. Stop. Sri D.K. Mishra, learned counsel appearing for the appellant, strenuously argues that the entire procedure followed by the Tahsildar is contrary to the statutory provisions, that is the OLR Act, and the finding that the core 5 point
5.71
5.72 decimals of land was ceiling surplus cannot be sustained in the eye of law. Stop. Further,
5.21
5.21 5.21. Further, the manner in which the land was classified as class 2 and its nature was changed cannot also be countenanced in law. I have perused the impugned judgments and have also considered the contentions raised by Sri Mishra. Stop. It is seen that both the courts below have taken into consideration the inquiry report relied upon in the OLR case to arrive at a specific finding that proper procedure was followed. Stop. Learned counsel for the plaintiff appellate has not been able to demonstrate as to how this factual finding is wrong. Stop. It is well settled that concurrent findings of fact are not to be interfered with in appeal unless it is shown that such findings are perverse, against the weight of evidence on record, or blatantly erroneous. Stop. Such is not the case at hand, inasmuch as both the courts below, as already stated, have found nothing wrong in the procedure adopted by the Tahsildar in the OLR case in question.
Your Lordship may also add that in the meantime, after the Chilling case, the lands have been vested to the state and already distributed since law.
Moreover, vesting ta kebe 1962 এই কেসটা কেবে হইতলা vestingটা এই ছাড়ুন moreover the lands were vested to the state government long since and have been distributed accordingly
to the beneficiaries.
Accordingly, to the beneficiaries, accordingly to the beneficiaries. Stop. This court therefore finds no compelling reason to interfere. Stop. The second appeal is therefore dismissed, not being admitted. Dismissed. Yes.
एवढा खाली पॉडिग्री ये पेंडेंसी देखे यार होता है
आया
बोल केस बड़ा पूरा केस पॉडिग्री पेंडेंसी देखे यार होता है
I don't really do.
Item 22, it has been listed under heading order portion of rule, right? Although it has already been admitted.
Admitted.
Your lordship, right? Order dated 3/7/2017.
We'll take it up then for hearing.
There was a defect से notice भी sufficient नहीं गुड़ा लोगों को ऊपर
Notice sufficient है नहीं
आज्ञा
देखिए office note कौन कुछ but it is not saying so. Office note doesn't say so.
But as per the cause list which has been published today, your lordship, it is right there.
Notice on status को notice issue वाला status को notice था जाएंगे तो other notice था admission notice था admit है इस साला पर hearing notice जाई थो ना
Appeal and return notice notice.
Appeal लो
to R6.
R1 to R13 में जाई छी
Again.
Notice gone.
not neither rating वाला such notice issue
R4 and R6.
You are appearing for whom?
It's for number 1, your lordship.
Only one.
Yes.
You can't appear for others.
No, your lordship.
You have not
I don't have an
instructed.
instruction.
Notice on R3 has been.
No, I don't know if it is not conflicting your interest. You may appear for them. You take instruction. Otherwise, it is what I put it.
कौन जा कोई भी पच्चर दे भी आ गया but
No, if they don't want to engage you, कौन अपना बात बोल रहे हैं जब if that possibility is there, then the matter can become immediately ready for hearing.
अब लेकिन instruction.
Hello.
Respondent number 5, 8, 11 and 12 some other counsel is appearing already, your lordship.
5, 7?
5, 8, 11
I
and
beg
12.
your pardon, my lord. I am appearing on behalf of Mr. A.K. Nanda.
All right. So respondent numbers?
Yes, my lord.
It was 2, 5, 8, 11 and 12.
Respondent numbers 2, 5, 8,
11 and 12.
8, 11 and 12 are represented by Sri A.K. Nanda. Sri J. Biswal appears for respondent number 1. He seeks time to take instruction as to whether he can appear for the remaining respondents. आगो प्रथम लिखंतु Sri S.P. Mishra, learned senior counsel appearing for the appellant is present. तापर से जुड़ा लिखले.
This has already been admitted.
This is admitted. See, that is why I am saying, why take notice again? If he can appear under the matter, we can hear it. Place this matter in the week commencing 29 July. I'm grateful about it.
Interim order to continue.
Interim order to continue. अब इतने लंबा नोटिंग से जो देजिन तो गुटी गुटी के देखी करिया पे क्या वन स्ट्रोक रही जो
Okay.
Obliged.
23
Yes, Lordship. I am permitted to submit on behalf of Mr. Tushar Mishra. Yes. This is a reversing judgment. Plaintiff has filed the suit.
Yes, Mr. Guru.
The plaintiff has filed.
Not been admitted so far.
No, my lord.
That's a 2018 matter.
Yes, my lord.
Yes.
The plaintiff.
You are the plaintiff.
Sorry, my lord.
You are the plaintiff.
I am the plaintiff.
Against reversing or reversing or
Reversing judgment. Reversing.
suit for
Allowed.
suit for
Suit for the declaration of right title interest.
yes.
That was allowed. In the first appeal, it was negative, my lord.
So what is your case?
Case is that in the year 1924, 47.75 acres of 47.14 decimal of land was leased out to one Haragobind Purohit, who was a minor, represented through his father Achyutananda Purohit.
It was leased out.
Leased out
47.14
by the Lambadar of the village Pandloi in the district of Sambalpur.
So this is prior to vesting.
Prior to vesting.
No, 24 hours.
24 hours. And it is under a registered list. that lease deed was challenged by some of the co-sharer before the assistant commissioner, deputy commissioner did then in the British rule. That revision was dismissed. Then they continue in the possessing until they are in possession of the land.
The plaintiff, how is the plaintiff related to?
Yes, I am coming to that.
You have a genealogy?
No, in 1986, the Hargovinda Purohit, he was the minor at that time, he pulled out the total land in favor of the present plaintiff. Appellant.
It was a sublease then?
No, it was a will.
It is a will, okay.
It is a will.
Okay.
Unregistered will in the year 1986.
Okay.
On the basis of which the plaintiff filed this suit. Is there any cause of action being to bring the suit? Whether the suit is liable to be dismissed for non-service of notice under section 80 CPC.
I think issue number 4 is important.
Yes, my lord. Whether the plaintiff has acquired any right title interest over the scheduled land by virtue of a registered lease deed executed by the ex Lambadar Gauntia in favor of the Hargovinda Pujari. Actually, it will be Purohit, my lord, who in turn transfer the same in favor of the plaintiff by will. Whether the defendant has any manner of right title interest by virtue of the recording of the land in the Hamish settlement as well as in the.
So 4 and 5 is the
4 and 5 that has been decided in favor of the.
Let us see. Let us see the concluding portion.
My lord, page 9. Internal page 9. Just before issue number 1 and 3. 7 lines from the bottom of the paragraph, my lord. So the court hold that the plaintiff is in possession of the suit land since the time of his predecessor in the interest, and in view of the observation of the Honorable Apex Court and the High Court in above 2 reported cases, this court hold that the plaintiff has got right title interest and possession over the suit land, but not the defendant. Accordingly, the issues are answered in favor of the plaintiff.
Okay. Then who went in appeal?
Appeal. They raised certain issue.
Who? State went in appeal.
State went in the appeal.
Yes.
They have raised certain issues which were not there in the trial court. They are neither pleaded nor any issue are framed. Just like state evolution, that came for state evolution and applicability of the sealing in under the OLR Act. It cannot be under the OLR Act because it is a the land is not lender. Though it is not totally cultivable land, only the agricultural land can be the subject matter of the sealing.
So come to the finding of the appellate court.
Appellate court, my lord. Page 7, internal page 7 of the appellate court judgment. Para 9. On perusal of the impugned judgment, it is found that the London trial court has taken issue number 4 and 5 together for consideration whether the plaintiff has acquired right title interest over the scheduled land by virtue of the registered lease deed executed by ex Lambadar Gauntia in favor of the Hargovind Purohit, who in turn transferred the same in favor of the plaintiff by executing an unregistered will, and whether the defendant has any manner right title interest over the scheduled land. After analyzing the evidence on record, the London trial court has given the finding that the plaintiff has got right title interest and possession over the suit land. The London government pleader referring the provision of section 138 of the Central Provision Land Revenue Act. There are 2 acts, my lord. One is CP Tenancy Act and it is a Revenue Act. Revenue Act is for collection of revenue. And this Tenancy Act is total control over the land, my lord. Advance his argument that the Lambadar has no authority to transfer any land on perpetual interest by executing a permanent lease deed like Exhibit 1. And this was not the ground in the written statement also, my lord. Written statement, they have raised 2 grounds only. One, the notice under section 80 CPC and the limitation. That is in the issue number 1 and 3, London trial court has negatived their argument, saying that before filing the suit, the plaintiff has issued file a petition to waive out the section 80 notice, which the court has already passed an order. So, basing on the registered lease date by Exhibit 1, the plaintiff cannot claim his title through his Haragovind Purohit. The second contention of the land and government pleader that all along the kisam of the land is a Gochara land and for which the same cannot lease out in favor of any person. Thirdly, neither the leaseholder Haragovind Purohit nor his father, Guardian Achutanand Purohit, had taken any step to record the suit scheduled land in the name of Haragovind Purohit during the major settlement. In respect of possession, no document is filed on behalf of the plaintiff like payment of premium by Achutananda Purohit on behalf of his minor son Haragovind Purohit, so far as the leasehold land as reflected in the LS lease deed marked as the Exhibit 1. Exhibit 1 is a registered lease deed. And likewise, not a single document is filed regarding payment of rent either to the Lambadar or
No, you did not file the original deed. That is what I read.
That is 100 years old, but we have called it from the sub-register and the PW1, who is a clerk of the sub-register office. He has come along with the volume and he has produced before the Planet Court bill.
All right, we'll admit it. Admitted, I think the state is to. Yes. I think we can take it up for hearing.
Yes, my lord. Yes, my lord. The LCR may be called for and any date may be fixed.
What substantial question of law? Let's see, K. Guru, Learned Counsel for the appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted. Are they following? Substantial questions of law. Question number 2. 2 Yes? 2. Substantial question number 2. No notice need be issued as Learned Sri A.R. Das, Learned AG, accepts notice on behalf of the state respondents that adequate copies of the appeal memo be served upon him within a week. LCR দরকার হবো? না, অচ্ছি মো করে। LCR?
LCR দরকার হবে। Because they have not filed a single document before the trial court.
No, but is the LCR required to be called for?
Maybe required.
Required matter.
All right.
The reference is made by the first appellate court.
Then back to the Balaram. Call for the LCR. List this matter. August what date karo?
12th August.
In the week commencing 12th August. Yes. How nice. Setting. Remaining matters tomorrow.